All right, we're going to go ahead and call the meeting to order. It is Wednesday, December 6th. Will the clerk please call the roll?
Counselor Eber?
Here.
Counselor Holen?
Here.
Counselor Wheel?
Happy to be here.
Counselor Sheldon?
Here.
Counselor Blum?
Here.
Counselor McGuire?
Here.
Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'm going to confess that ever since I became mayor, I have this vision that when I stand up that I'm going to forget the words to the pledge. It hasn't happened yet, but every time I'm like, oh my gosh, what are the, okay. What are the words again?
You should start singing the Star Spangled Banner. There you go.
Audience participation period. I see no one in the audience. There are also no members of city boards or commissions present. So we'll move on to item 7, the consent agenda.
Move to approve the consent.
No, I'd like to remove items 6B and 6C.
7B and C.
6. There's a new agenda.
Oh, sorry. I'm looking at the next meeting.
And
Never
6A.
mind. Okay, yes, 6B and C.
And 6A also.
And 6A. Okay. Well, let's start with 6A then. Counselor Blum.
Yep. As I was not in attendance, I would not be able to vote on that.
Same here for me.
Okay. Then I will entertain a motion.
Okay. Move to approve the minutes of the prior meeting.
Second.
It's been moved and seconded. All in favor?
Aye.
Aye.
Any opposed? And 2 abstentions. Item 6B.
As you might imagine, item 6B, I'd just like to insert in section 1 of the resolution, the City Council hereby gratefully accepts a cash donation.
Okay, so adding, did you say gratefully?
Yep, which is what we've done before.
Yes, adding the word gratefully. I will entertain a motion.
I move to approve item consent agenda 6B, resolution 44 series 2023, accepting a bench donation in memory of Tiffany Chesler with the addition of gratefully in the ordinance.
Second.
It's been moved and seconded. All in favor?
Aye.
Any opposed? That passes unanimously. Thank you very much to the Chesler family. Moving on, item 6C, resolution 45.
Yeah, and Director Farman and I had a chance to talk about this as well. I think probably everybody agrees that, you know, we ought to be striving to write our resolutions, ordinances, whatever, so that the plain language is as clear as it can be. And clearly when we did this one of the things wasn't. We talked about, you know, there's the general fund emergency reserve, there's the parks fund emergency reserve. And we said we wanted the parks emergency reserve to be in the for the parks to be in the parks fund and for the general fund to be in the general fund. The capital fund is written as 100% of the following year's capital budget, capital improvement program will be reserved. And it will be put into the general fund. But then when I was looking at the financial statements, Director Farman, and you can correct me wrong, Doug, if I'm wrong, what he did was, and his interpretation was, well, no, we're going to take 100% of that portion of the capital budget that would be attributable or that would come from the general fund, but that portion of the capital fund that where the money would come from the parks fund, we just pushed aside. I think that's what he did, which is not what the language says. It's talking about the full capital fund. The full capital budget, for instance, for 2025 is like $2.1 million, I think, something like that. Whereas $650,000 will come from parks. And so the emergency reserve is based on 50% or 100% of 1.5 or whatever that number is, less the parks number. So what this says is incorrect. And so there's two questions. A, what do we want it to do? And then let's write it so that it says what we want it to do. I can go either way. As you guys know, so go ahead, Dr. Farman. Why don't you?
Mayor, if it's okay, I did have a chance. I appreciate Mr. Holmes' phone call because I was able to talk to City Manager Thorson about this ahead of time. So we do have some proposed language. Out of the first reading, we thought that the council, the intent and the spirit was to let the Parks and Recreation Fund stand on its own as far as an emergency reserve. So we would like that capital portion of the Parks Fund to also stand on its own as far as the emergency reserve. So if we look at, and you've got the proposed policy on the dais here tonight, if you look at page 2, and I think this would clarify it. If we look at page 2, section 4, fund balance emergency reserve goals, and under C for the capital fund, it says there shall be maintained a reserve equivalent to the subsequent budget year fund forecast, and if we can add the language excluding the Parks and Recreation Fund CIP, the reserve for these funds will be kept inclusive with all other general fund reserves. So that would add some clarity, I think, that they would just be the capital fund portion of the CIP and not the Parks and Recreation CIP.
Okay, so if I understand, it's up here. Okay, great. So
and I don't have a slide for that, I'm sorry.
Okay, there is no slide. Okay, so that's what I wanted to make sure I understood what.
Can you say again what?
Yeah.
Be a change to what's on the dais.
Yeah, page 2, section 4, and then under the capital fund, there shall be maintained a reserve equivalent to the subsequent budget year fund forecast, excluding the Parks and Recreation Fund CIP.
And then do we also need to is the intent to make a corresponding change to the Parks and Recreation Fund to say that it's part of the CIP funds will be added to, it's 25% of the current budgeted?
I don't think so because that's based on the revenues.
Right.
25% of the Parks and Recreation Fund revenues. And when you look at the calculation, it's close to $1 million, which is over 50% of the fund balance in the Parks and Recreation Fund.
Okay.
So in reviewing that, Jim and I thought that was sufficient as an emergency reserve for operations and capital in the Parks and Recreation Fund.
Okay. And so in the event of some sort of emergency, I guess what we'd be saying is that the parks-related capital improvements most likely just wouldn't get done because we hadn't set aside emergency reserves to cover that. Is that accurate or no? Yeah. I see a couple people nodding. So if we're saying that we're going to maintain a reserve that's equivalent to the budgeted year fund forecast, excluding the parks portion of that, then if we ran into some sort of emergency situation where we needed to use our reserves, we don't have the money, the capital funds in reserves to pay for the parks part of it.
But don't they have surpluses in Parks and Rec that could cover?
It could, but we haven't. We won't have an emergency fallback position for those.
Well, we will have. I know it's a little confusing, and I think
it is confusing.
We apologize for that, but the thought is that we will have almost every single year $1 million in the park reserve fund, and that would cover probably any shortfall we foresee in that fund, and therefore I think we're covered.
Okay. So basically, we're saying that we're just going to have a flat number based on revenue.
Right.
And if we had a year where our projected capital improvements that were related to parks were huge, above that flat reserve, then maybe we wouldn't be able to fund all of it. We would just be able to fund whatever's in the reserve.
I don't think that's right. I mean, the point is that the reserves are there. If the undesignated reserves were totally depleted, I mean, everything's depleted.
Yep.
Then you're relying on the reserves at that point in time for emergencies or what have you. Right. Under that circumstance, what you're saying is true. We wouldn't have the money. We don't have it. That's unlikely at that situation. And the thrust is that by requiring that to be in there and putting it in the parks, you're actually then putting the Parks Fund in a position where it may be unable to now fund normal
right.
funds.
No, I understand. I just want to make sure that I understand. Right. I doubt it will ever happen.
Right.
I just want to make sure that I understand that number there may, if we got, I mean, hopefully that never happens, right? Where we've
right.
gotten so depleted. And it makes sense to me, frankly, that if we're in that dire of a situation, maybe we're not doing capital improvements in our parks.
Right. I mean,
maybe there are some other things that are more important at that point. But I just want to make sure I understand.
But I like that proposal. Like I said, there's 3 different ways that it could have been taken care of based on the language. I think that's the right way to do it, which is just to exclude that portion, and so which you've done with regard to the language. I might also just suggest, since we're fixing it, some minor tweaks to this section. I think that, again, I always like keeping things as consistent with language as possible, because when you see it worded differently, you're wondering if something's different. So I think that it ought to say, for the general fund, within the general fund, there shall be maintained a reserve equivalent to 50% of current budgeted revenues for this fund, excluding transfers. The Parks Fund. Within the Parks and Recreation Fund, there shall be maintained a reserve equivalent to the minimum of blah, 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 and strike the last line. You don't need it. It's within that fund. And then in the Capital Fund, there shall be maintained a reserve equivalent to the subsequent budget capital fund year, or budget capital fund year forecast, excluding the Parks and Recreation, which is what you'd indicated. And that keeps that language a bit more consistent, I think, at that point.
Okay, read what you had for capital fund again. There shall be
there shall be maintained a reserve equivalent to the subsequent budget year capital fund forecast.
Capital fund, okay.
Just to make it clear what you're talking about, because I fund a little F, you wonder.
Excluding.
Excluding, then that's the language that Doug had, excluding the Parks and Recreation Fund. CIP portion, is that whatever? Yeah.
Yes.
Okay.
And then the last sentence would stay there. Yeah. The reserve for these funds will be kept inclusive with all other general fund reserves. And then that, I think, makes it clear.
Is everybody clear on that? Okay.
It is a little, the reserve for these funds, should we be a little more specific about these funds? In that?
No, in the last.
Yeah, no, the last sentence, the reserve for.
Under capital fund, you mean?
Yeah, or should we say capital fund, or what, what? It's a little ambiguous.
How about just these reserves?
Well, I think the question is, does the reserve or these reserves refer to the capital fund reserve or all 3? By having at the end of paragraph C, it would seem to only apply to capital fund.
Which is correct.
Which is correct.
Okay. So I think you should say, that in each of them, you should say the reserve for the capital fund. And in B, you should say the reserve for the Parks and Rec Fund. And in A, you should say the reserve for the...
Well, yeah, so Earl's suggestion was that general fund would now read, within the general fund, there shall be maintained a reserve, continue on. And then part B would read, within the Parks and Recreation Fund, there shall be maintained a reserve equivalent to blah, blah, blah. Strike the last line because we just said that. And then capital fund would read, there shall be maintained a reserve equivalent to the subsequent budget year capital fund forecast, excluding the Parks and Recreation Fund CIP portion. Or something like that Doug read, period. And then it would say the reserves for the, instead of these, maybe the capital fund? For the capital fund will be kept inclusive with all other general fund reserves. Okay, does that capture that?
Yep, that does.
All right.
Okay.
Is there any other thoughts, comments? If not, I'll entertain a motion as amended.
I move to approve Resolution 45, Series 2023, adopting a new fund balance emergency reserve policy as amended in this meeting.
It's been moved. Is there
Second.
It's been moved and seconded. All in favor?
Aye.
Any opposed? Thank you very much. That passes unanimously. The 2024 proposed budget, Director Farman.
Thank you very much. Tonight we do have the City Council's final review of this and the second reading of two council bills, 8 and 9, adopting the 2024 budget and also levying property taxes and the city appropriations for 2024. We just have some updates from the first reading. The state enacted Senate Bill 23B-001, and that actually results in similar property tax estimates as Proposition HH. So we will go back to those Proposition HH city estimates that we had prior to that whole proposition vote. We also have an additional request after looking at some of the city attorney hours and the volume that the city attorney services has been reviewing this year. We are requesting another $20,000 for legal services just based on the volume, and the number of hours have gone up, mostly for the associate and also for the principal city attorney as well, but that's just based on the volume of issues the city has brought forward to the attorney's office. And we also have some more firm design costs. I guess that will be coming before council a little bit later this evening, but there is an additional $11,000 that we feel would be needed for those design costs on the Quincy Farm Big Barn. So that would actually affect the capital fund and the Parks and Recreation Fund, because that Parks Fund actually funds the Quincy Farm capital. And so in total, the city's 2024 budgeted revenues would be $18.5 million, and the expenditures $18.6 million. And if City Council agrees with those additions, here are the recommended motions, and I can answer any questions at this time about the budget.
So I just wanted to start with one to get it on the record. I think Director Farman sent an email to us that the property tax changes that the legislature did make really did not came out to be approximately the same as what we had originally budgeted for, because we had contemplated the passage of HH in our original budget. Is that correct? So there really are no significant changes to this based on the fact that Prop HH failed, but then the legislature passed their.
Yes, and I would like to confirm those are estimates that the city has made, so we won't know until the county certifies the assessed values.
Okay. And when does that happen? When do we provide, when is that all written in stone?
Yes, the former date was December 10th when the city would get those certifications, but now it's been pushed out to January 3rd, and then the city has 1 week, so January 10th, that we have to turn that around and actually sign the certification and get that back to the county. So they have until January 3rd to get that to the city.
Okay. And is that also the same time frame when we provide our mill levy information to them? Do we provide that in January?
Exactly. That's on the January 10th certification
okay.
from the city.
I just bring that up because, as many of you know, there was an editorial by the governor requesting that municipalities look at lowering their mill levies. And if I'm correct, that would take 2 readings. And we don't have 2 meetings. So that isn't really possible at this point. Okay. Other questions about the budget?
Just a quick question. Looking at this chart, I'm sorry, total revenue source is 18.48 and total appropriations 18.63. And I understand we're supposed to have a balanced budget. Is that still, it doesn't seem to balance to me.
That's a whole different discussion. As far as a balanced budget, that is a beginning fund balance plus revenues equals ending fund balance plus expenditures. That's the definition of a balanced budget, and I think that's really what the charter is saying.
So it's not
yes,
necessarily saying that you can only spend in one year what you bring in that year.
Exactly.
You have existing fund balances that you can use.
Because there could be capital items that you need to fund, so you've saved up over a period of time, and now you've got a large capital expenditure. That would be one example where your expenditures might exceed your revenues.
And somebody used the word charter. I have no idea what our charter says on this. I know that from time to time, people have said that municipalities have to have balanced budgets within that year, and there's a statute, and there is no statute that says that.
That was my understanding.
It does not exist in the, now, I actually never looked at our charter, so I don't know what our charter says. But I know that from a statutory perspective, Colorado statutes, there is nothing that says that. It basically says that we cannot run a deficit. Not in an annual year, but we cannot run where basically our fund balances go negative. But it's always been stated. It's like, that's why I always say, hey, words go floating over the landscape, kind of in search of affirmation. People have just repeated that over and over. It's got to be balanced. And I used to go, I don't think that's right. And it causes you to do things that don't really make you have the most accurate budgets in the world.
But for the record, let me state that we have very conservative fiscal management here and that we actually do have a balanced budget, whether it's required or not.
Right. Well, yeah, exactly. That wasn't my point, was to sit back and say we should be running it different. But the whole thing of going 18.433 and 18.4333, and it's like it's never needed to do that, ever.
My only concern is looking at this chart from a naivety perspective and seeing revenue being one number, expenditures being, appropriations being another number. It looks like it's a deficit, and we can't do that. So,
well, I think it's important for people to realize that we ran a surplus of over $3 million this year. So if we can't ever spend that money, then it would just sit there in perpetuity forever. And so I think that that's where the, we're spending some of our savings is for the layperson who may have questions about.
Well, that's what it's all about. I mean, that's why, to those that might wonder, what are we doing with those surpluses, those fund balances? Those fund balances are there because the city anticipates that there are, and we have multiple projects that we know are coming our direction that will not be able to be funded out of annual revenues. And we have an obligation to sit there and pay attention to that when it's coming. That's why those surpluses are sitting there at the end of the day. At such a point in time, it's always been my contention that at such a point in time that all of our known capital projects are taken care of or we know where we are, and we're still running surpluses and have a fund balance, I know at least there'll be one person on council that at that time will be voting for a reduction in our tax levies. I've always felt that way. But until we know what the impact of those capital projects are going to be, or other things such as, like you brought up, Mayor, about saying, hey, something could happen in the legislature with regard to capping revenues, things, increases in real estate taxes, et cetera. There are things that could come down the road. It's prudent to basically hold where we are until we have answers to these questions, and then when we know, then we take action.
And there will be, a ballot issue has been certified for the November 24 ballot that would cap property tax growth.
Really, so it's going to be on the ballot.
It's been approved by the Secretary of State. I mean, I guess there are still things they could withdraw it, they could change, but yes, it's been approved by the Secretary
And
of
it'll
State.
cap it at 4%.
Cap it at 4% growth.
Glad we
So,
have those,
yeah, so that that will be on the ballot most likely next November.
HH round 2.
Exactly. It's more like Tabor round 2. It's
Right.
property tax Tabor. But it does at least say to me that this is not the time to think of making mill levy reductions, because once
Absolutely.
growth is then capped, your starting point matters.
Yep.
So, other thoughts or comments also for anybody who might be watching or participating? I always think it's important to mention that we have a study session on the budget in October. We've had the first reading of the budget as well. So just because you may not see a lot of discussion or hear a lot of discussion right now does not mean that an enormous amount of thought and discussion has not gotten into getting to this point. I just want everybody to be sure they know that we consider this very carefully. It's one of our primary roles. Any other thoughts or comments? If not, then I would.
I move to approve Council Bill 8, Series 2023, a bill for an ordinance adopting a budget and levying property taxes for the city of Cherry Hills Village, Colorado for fiscal year 2024 on second and final reading.
Second.
It's been moved and seconded. Will the clerk please call the roll?
Counselor Eber?
Aye.
Counselor Holland?
Aye.
Counselor Wheel?
Aye.
Counselor Sheldon?
Aye.
Counselor Blum?
Aye.
Counselor McGuire?
Aye.
That passes unanimously. Thank you all very much. Council Bill 9, authorizing appropriations. Director Farman.
That was part of the presentation as well, but we do have a recommended motion to adopt the appropriations, if council can consider that.
We don't necessarily need to, I don't know if you have any discussion about that, but
Yeah, he's on Council Bill 9.
yeah,
Okay.
Not Agenda 9.
Okay.
yeah. So it's
So
this
no
motion
discussion.
here. It's this motion here unless there's discussion, somebody wanted to.
We're good.
I move to approve Council Bill 9, Series 2023, a bill for an ordinance of the City of Cherry Hills Village, Colorado, authorizing appropriations for fiscal year 2024 on second and final reading.
Second.
It's been moved and seconded. Will the clerk please call the roll?
Counselor Eber?
Aye.
Counselor Holland?
Aye.
Counselor Wheel?
Aye.
Counselor Sheldon? Counselor Blum?
Aye.
Counselor McGuire?
Aye.
That also passes unanimously. Council Bill 10, Director Farman.
All right, thank you very much. Oh, sorry. Let me skip ahead here, add some extra slides. All right, so this is Council Bill 10 and second final reading related to the city's sales tax municipal code. And this is to create the intent or purpose for Chapter 4, Article 4, the retail sales tax code. Here is one update. This is a result from the council's first reading, and it's now incorporated in the proposed council bill. The purpose and interpretation section is now an introduction to this code section, and it's proposed to be shown at the beginning of the sales tax code, similar to other surveyed city code sections. So the new section would be code section 4405. And that is the only update from the first reading, so I can answer any questions, and if not, here's the recommended motion.
Are there any questions, comments? If not, a motion?
Okay. I move to approve Council Bill 10, Series 2023, a bill for an ordinance of the City of Cherry Hills Village amending Chapter 4, Article 4, concerning purpose and interpretation of the retail sales tax code on second and final reading.
Second.
It's been moved and seconded. Will the clerk please call the roll?
Counselor Eber?
Aye.
Counselor Holland?
Aye.
Counselor Wheel?
Aye.
Counselor Sheldon?
Aye.
Counselor Blum?
Aye.
Counselor McGuire?
Aye.
That passes unanimously. Council Bill 11.
All right.
Also,
we'll
Director.
just keep going here. This is Council Bill 11, and it's the second and final reading related to the city's municipal court code. And this bill authorizes court restitution and updates the statutory reference. After discussing this topic briefly, this would propose to add this section to Municipal Code Section 44. Oh, I'm on the wrong. Sorry, we've got to go on the next one. Okay. We had one extra slide in there. This is updated from the first reading. It's updating Section 1 of the Council Bill. And we have two changes as a result of Council's previous discussion. Subsection 8 of Section 2480 now references the municipal court rather than the municipal judge. And then also subsection 9 it references Title 18, Article 1.3, which is Part 6 of the Colorado Revised Statutes. So two changes from the first reading.
Okay, thank you. Any questions or comments about that?
Doug, did you just read that backwards? Did anyone else catch that?
Yes.
He flipped
It now says municipal court, or judge, rather than municipal court.
He said it.
Yeah,
he
you said it the
inadvertently
other, you said it the other way, but
Okay.
we know what you meant.
Trying to be consistent there,
Okay.
yes.
I don't have anything else.
Okay, then a motion, anyone?
I move to approve Council Bill 11, Series 2023, a bill for an ordinance of the City of Cherry Hills Village amending Section 2480 of the Cherry Hills Municipal Code to authorize restitution in municipal court and update a statutory reference on second and final reading.
Second.
Subject to, do we have subject to the two other changes?
No,
or-
that's what's included in the.
Okay.
Second.
It's been moved and seconded. All in favor? Or no, clerk, please call the roll.
Counselor Eber?
Aye.
Counselor Holland?
Aye.
Counselor Wheel?
Aye.
Counselor Sheldon?
Aye.
Counselor Blum?
Aye.
Counselor McGuire?
Aye.
That passes unanimously. Council Bill 12. That is Commander. Director Farman, you're retired.
Good evening, Madam Mayor and council members. This evening we have the second and final reading of Council Bill 12, Series 2023, repealing Article 7 of Chapter 7 of the Municipal Code concerning regulation of unmanned aircraft systems. Council discussed changes during the first reading of this council bill that included adding language that the city opted not to include registration of drones. However, based on subsequent additional direction from the city attorney after the meeting, no changes have been made to the council bill since the first reading. But I'd be happy to answer any questions that you may have.
Councilor Holland, do you have any comments you'd like to make?
I have some comments. I don't have any questions.
Okay.
So maybe
Yes.
the comments are more appropriate when we discuss the.
We're discussing.
Yeah, and I, first of all, I'd like to thank the city attorney. The memorandum that you provided was very helpful, particularly the section providing more comprehensive review of federal law on unmanned aircraft. That section was quite helpful. I still have some disagreements on a couple of the conclusions reached on preemption, particularly as it relates to the registration section. But I don't think that would be helpful and necessary to go into right now. Rather, as I mentioned in the last council meeting, I am in favor of repealing this section of the municipal code, and I'm good with the wording of the proposed ordinance doing so. But in order for me to get to that point, my interpretation of the clause in the 7th recital that states, quote, pursuant to the FAA's exclusive authority to regulate aviation safety and the efficient use of aircraft, unquote, is that it only applies to those sections of Article 7 of Chapter 7 that are, in fact, preempted, and that it does not mean that every provision of Article 7 would necessarily be preempted. which is different than saying repealed, right? So with that understanding, I'm prepared to vote in favor. If it was me, those words would actually be in there, but I'm not prepared to fight that. I'm just prepared to go on the record and say, that's my opinion, and with that interpretation, I'm prepared to go forward. I would have rather have seen wording like that in there that said, specifically said, those sections of Article 7 that are in fact preempted are such, but I'm not going to make a big deal out of that. So that's my, those are my comments.
Any other comments or questions? All right, thank you for that. Then I'd entertain a motion.
I move to approve Council Bill 12, Series 2023, a bill for an ordinance of the City of Cherry Hills Village repealing Article 7 of Chapter 7 of the Cherry Hills Village Municipal Code concerning regulation of unmanned aircraft systems on second and final reading.
There's a motion and a second. Will the clerk please call the roll?
Counselor Eber?
Aye.
Counselor Holen?
Aye.
Counselor Wheel?
Aye.
Counselor Sheldon?
Aye.
Counselor Blum?
Aye.
Counselor McGuire?
Aye.
And I also here would just like to state for the record that this ordinance regarding unmanned aircraft has absolutely nothing to do with the police department's drone and their use of that drone. Not related in any way, shape, or form. Next up, Council Bill 13. Also the commander.
Yes, ma'am. Continuing on, tonight before you is the second and final reading for Council Bill 13, Series 2023, repealing and reenacting Article 4 of Chapter 6 of the Municipal Code concerning security alarm systems and amending Section 7-1-40 concerning exceptions to public nuisances. Council had no changes at the first reading, but I would be happy to answer any questions that you may have.
Any questions, comments? If not, motion?
I move to approve Council Bill 13, Series 2023, repealing and reenacting Article 4 of Chapter 6 of the Municipal
Code
Lights
concerning.
out.
I
I
can
have
pull
here
it back
code
up.
concerning security alarms. It's right here. If you need
There you go.
I got it right
it. Okay.
I move to approve Council Bill 13, Series 2023, repealing and reenacting Article 4 of Chapter 6 of the Municipal Code concerning security alarm systems and amending Section 7-1-40 concerning exceptions to public nuisances on second and final reading.
Second.
That is moved and seconded. Will the clerk please call the roll?
Counselor Eber?
Aye.
Counselor Holen?
Aye.
Counselor Wheel?
Aye.
Counselor Sheldon?
Aye.
Counselor Blum?
Aye.
Counselor McGuire?
Aye.
That passes unanimously. Moving on to Council Bill 14, Director Workman. Where are you? Oh, you're over there.
I'm hiding. Good evening, Mrs. Mayor and members of the City Council. The next discussion before you this evening, as was just stated, is Council Bill 14. This is a bill for an ordinance that would amend Chapter 16 of the Municipal Code, which is the zoning code, specifically amending variance and floodplain variance approval criteria and adding a definition for the term exceptional hardship. The presentation this evening and the associated materials in your packet excuse me, are a result of council direction to clarify what constitutes an exceptional hardship, as that term relates to land use applications. Specifically, council had a discussion in May of this year to discuss this topic and directed that the addition of a definition for the term exceptional hardship be created to add additional clarity and consistency of application. And as channeling my inner Councilor Holen, we did take the opportunity to look at some of the additional language surrounding the variance and floodplain variance language, and we are proposing some minor text amendments to either increase clarity or make the code a little easier to read. As council may recall, there are two applications, two land use applications that require the establishment of some type of a hardship. The first one is the variance application. Again, to refresh the collective memory, Variances are heard and acted upon by the Board of Adjustment and Appeals. Those do not come before the City Council. But you can see the first approval criteria for a variance is bolded there, that the applicant would suffer an exceptional and unnecessary hardship. The second land use application that requires the establishment of an exceptional hardship is the floodplain variance. Those applications do come to City Council for your ultimate consideration for approval with conditions or denial. Before it gets to you, it is heard by the Planning and Zoning Commission, who makes a recommendation on what action they would recommend to you. If you recall, currently the code does not have a definition for exceptional hardship. Based on your discussion back in May, there was a desire to create that. And so between the discussion in May and this evening, the City Attorney's Office and myself have been coordinating and working through language. And what's before you this evening is what was recommended by the Planning and Zoning Commission. So I won't go through each individual change in great detail, but I would like to highlight them. The first one, it falls in the category of clarifying the code. If we're going to define the term exceptional hardship, it would be unnecessary to have exceptional and unnecessary hardship. The second one is a clarification. Right, that variances run with the land. The addition of the language that's underlined as provided for in section 167520G4, again to clarify how variances are applied over a period of time. And then the third amendment would be to make the code a little easier to read. So as proposed, it would read, including standards referenced therein, have been weighed in favor granting of the variance. The crescendo for this set of text amendments is here and is the definition for exceptional hardship. Certainly welcome any comments or conversations associated with this. When we looked to draft this language, we looked to make it clear and concise, and not overly descriptive, if that makes sense. Overly detailed, I guess I should say, is probably a better way to say it. Let's be clean and to the point of what an exceptional hardship is and what it isn't. And so you'll see there, it would mean the impairment of the reasonable use of the property, period. Exceptional hardship does not mean the ability to obtain profit from or to maximize the use of the property. As I mentioned, Planning and Zoning Commission did discuss these proposed changes. They did so twice, actually. Back in September, we met with them. We had a really good conversation with them. And the result of that conversation was, let's go back, let us staff in the City Attorney's Office go back with the input that we received from the Planning and Zoning Commission and make some edits, make some changes based on that conversation. We did that. And we went back to them last month in November, and they were presented with the minor text amendments that have been presented to you this evening. They had no comments on those, but they did have a good discussion related to the definition for exceptional hardship, and they did make some minor tweaks. Those are highlighted in your packet. If you'd like to discuss those, I'd be happy to do that. One, I wanted to make sure that you were aware that Planning and Zoning Commission does take their role of reviewing that language seriously, as you would expect. And ultimately, I think we came up, the collective, Planning and Zoning Commission, as well as staff in the City Attorney's Office, came up with a definition that was a little more clear and concise. And that's what is presented before you this evening. So with that, my presentation would be done, but I certainly would welcome any discussion or questions or thoughts on the issue.
Thank you. So I'd like to do this in two steps. First, are there any comments or questions about the text changes before we talk about the definition of hardship? No. I had one, which is...
I've got some.
Okay, which was the variances run with the land, period. Every variance shall transfer and run with the land. That seems redundant to me. Do we need that first part? Could we strike variances run with the land and just say every variance shall transfer and run with the land as provided for in section?
as the city attorney is looking for that,
Yeah, is that
I
like a
would
subheading
chime
or
in
something,
that
or
is a format consistency
Yes.
with the rest of the code. So there's nothing saying you can't do it, but it would
Okay.
make that particular item different in terms of formatting than the rest of the
Okay,
items.
because I don't have all of it here.
Yeah, each one has sort of a subheading as you go down, so that's why
Okay,
that's.
fair enough, then I can live with that. Counselor Holland, did you have something else?
Yeah, I did, with regard to 16.9.130, exceptional hardship, and I kept contorting myself with this, but I just want to make sure that we're clear, because sometimes when you read the words, you read them one way and then you read them another way. Exceptional hardship means impairment of the reasonable use of the property. And I just want to make sure that somebody couldn't come along and basically go, hey, I'm proposing to put this structure over there, and that's a reasonable use of this property, and you're impairing my reasonable use of it.
Well, yeah, I actually felt like we're just kicking the can to now what is reasonable mean.
I was
Well,
just gonna say,
but that's the next thing, which
I was just going to say,
Well, I
we've
think the
traded
next
one
sentence, I think the next sentence covers it, though.
It does, although I think that should be, but I want to come back to that, what I just brought up, because I want to make sure that if nothing else, we got on the record saying it doesn't mean that. So if you come bringing that, go to the record of what we intend, and our intent is that's not what that means. But exceptional hardship in this case, when you read it in context, I don't think it should be exceptional hardship does not mean. It should be reasonable use does not mean the ability to obtain profit from or to maximize the use of the property. So exceptional hardship means impairment of the reasonable use of the property, which does not mean the ability to maximize profit. Maybe that's one and the same, but to me.
So I would offer that was a discussion point at the Planning and Zoning Commission.
Okay.
Originally, we had to obtain maximum profit from, and the discussion was related to whether it's a minimum profit or a maximum profit doesn't matter, right? Profit does not factor into the exceptional hardship concept, right? Exceptional hardship is by its nature something physical and not a tangible monetary gain. So just offer that for
I
discussion.
think Earl's question was whether it should say reasonable use does not mean.
Does not mean as opposed to exceptional hardship does not mean.
Yeah, which I think that makes sense to me.
And we're further defining what that is.
Yeah,
but
city attorney's nodding.
Well, if I think that would make sense. I would just say, to the point about kicking the can down the road, at some point, no matter how much you drill down on this is in the hands of the Board of Adjustment, right? But setting forth a definition that you're 100% behind and clear on and feel that gives them the guidance to apply in exercising that discretion, because at the end of the day, it is a discretionary decision in the confines of our 9 criteria that have to be met, right? Which are pretty restricted.
Well, and so I wanted to think back to several circumstances, either real or hypothetical or whatever they might be, to see where, if we feel this definition would have supported what we felt the outcome should have been.
Well, let me cite one example. Let's do hypothetically.
Yeah.
A golf course comes in and says, we have to adjust the floodplain because we had a problem with the, I can't remember exactly, but it was a glimmer, but where the retaining wall was a problem. And my question is, looking at this, I don't know how we would have voted on that if this was the definition we were dealing with at that time. You're talking about the definition saying that does not mean the ability to maximize use. Well, were they here to maximize the use, or were they here to be impaired for the reasonable enjoyment? And I can't answer that. I think that it's an unknown, even under this definition. So
I think the swimming pool is a similar one. I actually think this clouds the issue even more. Really? Because to your point, Earl, well, yes, it is reasonable to want to put a swimming pool, but they were told no because there was another place that they could put a pool. It wasn't as nice of a place, and it wasn't as convenient, and it wasn't as good, but there were alternatives. And maybe that's another one of the criteria in the.
I was going to add to that. I'm sorry, I didn't mean to cut you off.
I was just going to say that's an interesting thing because I was, doing a little research, including little AI chat GPT stuff, just to kind of see what they'd come up with. And the interesting thing is that when they're looking to define exceptional hardship, they define exceptional hardship by basically quoting all of the rest of our criteria. In other words, the exceptional height, it's almost like you don't need this. It's like going, no, you got to meet this, which, by the way, even if we did it or not, it's still like going, it is still an extraordinary remedy. It is still no design alternatives available. It is the minimum that could allow possible use of the land, building, and structure. All of those are still there. And I thought that was interesting because I was like, okay, maybe I can get ChatGPT to tell me a nice definition for exceptional hardship and then basically quoted back our criteria at me. And I'm like, well, you can't do that. But it was interesting to see that.
Well, I think I could quote I think I said, your code does a really great job of codifying all of the law around variances. Hardship is sort of the umbrella, and most of these, not all the criteria, but most of them are elaborations on a theme, right, of hardship. So you're spot on.
Right.
And it's a matter of keeping this in context together and making sure you guys have a definition that you're comfortable with.
So am I to understand that if we meet our 9 criteria, then 1 through 8 equals exceptional hardship, so that we don't need, or 1 through 9, excuse me, so we don't need a definition, because if you meet those things, then you automatically qualify as exceptional hardship. And where I'm going with this is we go through all of this work to try and say that it is an exceptional remedy, but then we turn around and say it's on the reasonable use. And reasonable seems like we just step backwards to make it broader than what all those 9 criteria are. To me, it means the impairment of almost any use or any of the, the ability not to use, so that you have in effect equated to a takings. I know that's not the right analysis, but the idea here is that if it's an extraordinary remedy of last resort, it should only be if there's really no alternative. And reasonable use is more than last resort.
So I'd like to respond to that. So your question about, does it mean if you meet all 9? No, because some of those are not quite on the hardship. But it's also important to keep in mind the context in which this definition is used in your code. And part of the trick here also was coming up to sort of respond to the inquiry here, was to come up with a definition that's of utility in the floodplain variance context as well as in the regular zoning code context. And in this context, hardship is used under the 9 criteria in terms of the land, right? So the applicant would suffer, and right now it reads, an exceptional and unnecessary hardship as a result of the application of this chapter, which is not generally applicable to other lands or structures in the same zone district because of the unusual configuration of the property boundaries, unique or highly unusual circumstances related to the location of existing buildings or structures thereon, existence of exceptional topographic conditions thereon, or comparable circumstances that are specific to the subject property. So the hardship definition is applied in your code in the context of uniqueness of the piece of property, not all kinds of things throughout all the criteria, right? And
like a lot that's 80% in the floodplain, which would mean they couldn't build anywhere.
Right.
Well, and to that point, when you're talking, Kathy, with regard to 1B, the unique, or one of the things, every time you read these things, right? I mean, you always find something you didn't find the last time.
True.
Unique or highly unusual circumstances. I'm good with highly unusual circumstances. I started to go unique. I mean, every property to some extent is unique.
That's true.
In some way.
Yeah.
Highly unusual, I think, is a different definition than unique. It's a much more restrictive type of a thing. So I actually, when I was reading that, not that we ever, but I almost wonder if unique ought to be out of there.
It's also subject to as much interpretation as reasonable, right?
Yeah.
Highly
Right,
unusual.
exactly.
I mean, so, yeah.
But it's where we're going is what we're saying is that we're back to the point where we don't want a definition of exceptional hardship. We want exceptional hardship in there, but we don't want to define it. We just want to leave it as, which then goes down and it just basically says your 8 criteria, which I know is different because I'm one of the ones that discussed this early on, saying we ought to define it. But I'm thinking that and you made a great argument, we're
Yeah.
weakening it.
I feel like reasonable is a pretty low bar.
Yeah, you had a good point.
Yeah, I mean, like I said, I think we're trying to say that this is a last resort remedy for somebody who has very special circumstances on the property. And reasonable use means everybody else on my street has a 5-car garage, so I want one too. Is that reasonable? Well, to you, yes. To me, no. To somebody else, who knows? I'm just trying to understand that I think what we're trying to do is we're not trying to weaken the underlying rule for floodplains, at least, that there is supposed to be very limited, if ever, development within floodplains. You know, other hardships for other things. I mean, I'm more concerned about floodplains, I guess, than I am about other types of hardship situations. But, you know, I want to make sure that this definition doesn't lessen the underlying desire to make this very difficult to obtain.
There was, and Al, maybe you remember, there was a situation years back with a patio that had been constructed and it went like into the setback or something, and they came and asked for a variance. It was already built.
It was already built.
Right.
And they came and asked for a variance, and it was declined. And I think that, you know, a patio seems like a reasonable use.
Councilor Blum always likes to point out I was on BOAA at the time.
Wasn't that the one car
You're
garage?
raising.
Well, there was a garage as well. This is a patio.
Oh, this was the
No,
patio.
this was a patio. Earl was on the Board of Adjustments when that came from him. And the issue related to, it was already built. So I'm trying to think through now under this definition, how this would apply in a situation like that. Also, how it would apply, I think with your pool example, Katie, if they got another alternative, there's no question, whether it's reasonable or unreasonable. But I guess with that patio, the question was, there was nowhere else to put the patio, from what I remember.
Well, they could have made it smaller, though.
Oh, it was smaller. They just had to shorten it by 10 feet.
Is that what it was?
Yeah, because they built 10 feet into the setback, and it was like
right.
a 20-foot, I don't know what the numbers are, but it was
Right,
like,
somewhere.
and they just had to, and the interesting thing is okay, is the exceptional hardship, the fact that now they got to rip it out.
Yeah.
But I think there was a clear violation. They violated the setbacks without getting a variance, and so you don't get to claim a hardship
Because you already did
when
it.
you already violated.
Yeah.
Right. I mean,
Well, but then there was.
Well, yeah, that's right. Yeah,
there was
yeah.
another situation
That's right.
then with the roof that was built too
2 feet too
high or
Right.
something,
3
and
feet too high.
we ended up, not we, but there was a variance granted for that because they didn't want to make them tear it
That
off.
was Randy's
There was
decision.
there was
That was Randy, yeah.
there was specific legal advice given on that one.
Yeah.
Yeah.
Okay.
Yeah.
Yeah, exactly. I mean, it was, I think if the board had felt that it was an attempt to circumvent the rules, it would have been a different outcome.
Right.
But it was a situation where the homeowner, the builder made an assumption that was erroneous, and the dominoes started to fall, and the homeowner would have been, the resident would have been victimized pretty heavily by this whole thing, although it was the doing of his builder. And
Well, so here's another hypothetical, and how would this relate to these definitions? You have a 6-acre lot. A lot of it is within the floodplain. Let's say 75% is in the floodplain. You go to subdivide the lot. You create a second lot that 90% of it is in the floodplain. And now no home can be built on that second lot. But somebody comes in and says, well, now I have this lot, and 90% of it's in the floodplain, so I need a variance in order to be able to build a house. Obviously, not being able to build a house is a pretty exceptional hardship.
But
you
you buy
created
with
it.
full knowledge
Yeah.
of whatever's reflected on the real estate records. And I think that's your own gross negligence.
I agree with Susan. But moreover, to your example, they went to subdivide. That's got to be approved by the municipality, in this case, us.
Right.
I can't imagine if they went there saying, okay, you can do it, but by the way, there's a restriction on there. You'll never build on this lot because there's only 10% buildable. So we're granting your subdivide with that proviso. If the city didn't do that, Susan's, still holds. I mean, they're going into it knowing, but still at the end of the day, the city should have dealt with that right from the get-go.
I know of 2 instances where people have bought lots that were mostly in the floodplain, torn the house down, and were given permission to build another house.
In the floodplain?
Yeah, because, otherwise the lot is useless.
Yeah. And if it was already existed, it sounds like they had tore down a house that was in the floodplain, and now they're replacing it.
I don't remember
I
all
think
the
this
details.
situation is they should have grandfathered the site by not tearing the house all the way down.
Yeah.
I know of one situation where that
Yeah.
was the case. They tore the house down before they had.
Yeah.
Well, and again, I think that in your situation, you're saying that tearing down a house is the affirmative act that we said cannot equate to creating your own hardship by then saying that it's unbuildable. And I'm going a little bit, I think, on my recollection of what our city attorney had said about, in the last meeting, when we were talking about the idea that you can't create your own hardship here. I guess buying a piece of property that's 90% in the floodplain and then complaining that you can only build a house on 10%, to me, is creating your own hardship if you didn't do your due diligence. I don't think there's any rule that says that you are, that you're, the expectation is that you have a patio of X size, and if it means you can only have it of a smaller size, I think that's not.
I can see having a different definition for the floodplain issue and the zoning variance issue. Because I think in the zoning variance, you do have to meet those 9 other criteria, and those don't come into play in the flood zone. So I think if you've met all of those criteria and you can show that it's what you're asking for other people are allowed to do in your neighborhood, it's not going to be a nuisance, it's not because of your own fault, and it still otherwise comes within the zoning requirements. You're not asking to build an apartment building or an ADU, or an ADU is not permitted. To me, then I think reasonableness should come more into account. But I agree on the flood zone side that maybe reasonableness shouldn't be the determining factor.
But one of the things, though, is that, under the master plan, Cherry Hills is very, very protective of floodplains. Mm-hmm. In other words, we've had the former mayor, we've had other people here that have basically said, you're not going to build in the floodplain. We're not going to let you build in the floodplain unless there is a really, really valid reason. That has been kind of the MO of Cherry Hills. So even though I get your point, the question is,
well, what I'm saying is,
what
if we kept exceptional hardship as a concept in the flood zone variance, but when we go back to the zoning variance, not flood zone, but we just say if we reword this number 1 to take out exceptional and unnecessary hardship. Let's just leave that concept undefined in the zoning or in the flood zone paragraph, and instead talk about maybe an unreasonable result. I'm not sure how you would reward it, but just say basically, if you meet all of these requirements, including the reason you're asking for this is because of A, B, C, or D, and then you also meet 2 through 9, that it's a reasonable request. I think if you're asking to do something to your property that is because of the unique or unusual circumstance related to your property, and there are no design alternatives, strict enforcement of the provision deprives you of the rights enjoyed by the most of your neighbors, it doesn't result from your own gross negligence. I mean, you go through this whole list, it's pretty, I don't think it's unreasonable for someone to say, I would like to be able to do exactly what my neighbors are doing, but I can't because I have an unusually skinny property, or I have a property that's unusual for some particular reason.
So 2 examples. One that somebody reached out to me about, they have a property that is kind of an odd shape, and they back up to that tiny little triangle up on Hamden, over on the west side. Yeah. Mm-hmm. But and I don't remember the exact details, but because of the way our fencing ordinance is written, they can't have a solid fence on Hamden that backs on the little part of their property that backs to Hamden. And they're like, seriously? Like, this is a super busy road, and that to me.
You mean because their property backs to that little triangle?
Yeah, and it's because of the way the
It's not
fencing
directly
ordinance is.
on
It's
Hampton,
it's a
on
big
that,
enough
yeah.
lot that they can't have a solid 6-foot fence,
Right.
but they don't border a highway because it's not directly on Hamden. It
Right,
backs up
right.
to a little
Triangle.
right?
Yeah.
So, or something along something like that. And so they reached out to me about the fencing ordinance, and I'm like, well, I don't really know that we can write the fencing ordinance to accommodate your situation, but I hope you'll make use of the variance process, because that's exactly,
And
in my
that
mind,
seems
what that's
reasonable.
for.
Right.
Um,
Or not unreasonable.
Right. And then there was another case where it's a very old lot. It was, platted 100 years ago, and it gets right where the house is, the lot gets very narrow. It's kind of wider on the front and wider in the back, but right where the house is, it's narrow. And they wanted to build a garage, and a detached garage, and there's nowhere that they can put it without encroaching into the setbacks,
Right.
because of the tiny width of the lot right there at that point, which is where the house is. So, those kinds of things, you want to be able to use common sense, I guess, is the.
And I feel like
It's hard,
I feel like we've made 16.7.520B pretty restrictive because of all of the conditions that we attach to it. Whereas when you, and so I guess what I'm saying is, I don't know that unnecessary hardship necessarily belongs in this provision. Maybe we don't define it, but we only have it in the flood zone section, and we take it out of this section.
So then, Susan, are you saying that in other words, for B1, rather than talk about who the applicant would suffer, you're saying, because above it says no variance shall be authorized unless the board finds all the following. The request for a variance is as a result of the unusual configuration of the property, blah, blah, blah. In other words, 1 is the basis for the request, and it's as a result of those 4 things, and then it has to satisfy the other criteria.
Yeah.
Is that kind of?
Well, you have to satisfy all 4 of them. And 1, you need to satisfy one of those 4.
Right.
Or I'm sorry, you need to satisfy all 9 of them.
Right.
In number 1, it has to be one of the 4.
One of the 4.
Right.
Right.
Yeah. But then you just take out the concept of exceptional and unnecessary hardship altogether.
But you would leave that definition in for the
For the
floodplain.
zoning.
I agree 100%.
For the floodplain, rather, yeah.
That feels a lot better. When I was involved with Board of Adjustment and Appeals, there were times that we would get what seemed like a very reasonable request. Air conditioning units in a swale going to be replaced, And if we had stuck hard and fast to the rules, we would have forced the owner to relocate those air conditioning condenser units up to the house where it would have been very visible. All of the neighbors preferred the location that the existing condensers were in because they were out of sight, they were down in a swale, but they wouldn't have met all of our zoning criteria. So we would have forced them into a situation which would have been aesthetically worse, and neighbors would have been less happy and all the rest of it. And it was a replacement rather than constructing new. It just feels to me like there is oftentimes a uniqueness and a consideration that doesn't always. Now, there were times when, you know, folks came in with requests that were just trying to stretch the rules purposefully. And those are easy to say no to. But the ones that are in that kind of gray area and the uniqueness of that particular property, I think, I guess I would encourage us to trust the Board of Adjustment and Appeals to be thoughtful and wise in their interpretation of that specific request.
I agree with your overall premise, although your example, though, throws me off a little bit. Because, again, and this is the thing that when I was on Board of Adjustment is people lose sight of all of the criteria and sit back and go, hey, there are no design alternatives for locations or buildings that would obviate the need or the request or the variance, and aesthetics is not a consideration.
Yeah, I mean,
and that's all. It's always important. I mean, and if we ever didn't want these, we can change them. But right now, they are there, and it's important at the end of the day that again, it's an extraordinary remedy. And I agree. I think I could come around to saying we could take out an exceptional and go with the language that Susan's proposing for the variances generally, and just say you got to meet one of these 4, and then the other 9.
But then you would leave it in for the floodplain variance, because I think, we just talked about, I think it clarifies it by having that definition there for the floodplain.
Right. Although picking up on that, you know, the example that you're utilizing is that with the exceptional hardship in there and this kind of the discussion we're having, you know, you started it by saying, hey, I don't know where we'd come out on the Glenmore thing, the golf course thing. And I'm agreeing with you. I don't know that the decision would come out the same.
I'm not saying that you include the definition, the reasonableness concept in the definition. I'm saying take that out.
Right. No, did I just use the word reasonable?
Okay. I'm sorry. I thought I misunderstood you.
Are we talking about floodplain or about?
Talking about the floodplain.
Floodplain, yeah. You're talking about leaving in
the
exceptional hardship for the floodplain thing.
Right.
Yeah.
Which, I don't know, what do you, I mean.
Well, I think you have more direction then if we do that.
I think so too. I'm coming around to that way of thinking.
I mean, I think I was one of the people who, you know, stood up and ranted saying that we needed more directive as to what is exceptional or what is hardship, because I don't know, I think case law is out there. I think there's a whole lot of, you know, what boiled down to individuals on whatever review board it is that's looking at, whether it's council or Board of Adjustment, saying, well, this is sort of what I feel. And we want it a little bit more standardized. But I'm not sure that I like the concept of defining this now. I guess I don't mind using the word exceptional hardship, especially within the idea of the floodplain. I'm kind of doing a 180 here and saying that, you know, I don't like our definition enough to say that we got to use it. I think if, whether it's council or adjustment and appeals, understands that these are variances that are the exception, not the rule, and go into it with that and some of the, sort of that preamble and say, these are the criteria that we think you have to look at for an applicant, and the applicant and the reviewers understand that it is a high burden, then I think that that will command the level of review and thoughtfulness that will not make these handed out like candy at Halloween. I think it will be rare still that you will get, or only in merit, I don't say rare, because I think it's only in the exceptional situation will you see somebody qualify for a variance.
And, you know, I mean, what's it been, about 2 years since we had the last BOAA meeting? You know, it's not like...
Since I've been on for a year, we haven't had any.
I was going to say, since I've been here for a little over 3 years now, we have not had a meeting with a case.
Yeah, so it's not like these are very frequent.
But
and then the exceptions would be yet less frequent. But
I think we have a couple coming up, I think, that are on our long-range agenda that gets handed out to us. We have a couple of permits that are out there for, I think, floodplain variances coming up somewhere down the road.
I'm not aware of any.
Yeah.
But to your question, and this is the thing, I remember now looking at this, this was a question I had once before. You know, 167520 is for general variances, and it sits back and it says very clearly, it is an extraordinary remedy. Doesn't say that for floodplains. And again, there's always, I mean, it's always kind of a lawyer thing. You're like going, you said it here, but you didn't say it here, so there must be a difference. And I've always questioned that because floodplain, like I said, I always operated from the standpoint that the master plan, floodplain's a big deal, and you sit back and you go, it's actually a lesser deal.
Well, it may be that it makes sense to add that language to
that's
530.
kind of what I'm hearing.
Yeah.
Right.
I think floodplain variance is an extraordinary remedy.
Yeah.
Well, it still is, you know, what is exceptional to some residents may not be to others. I really think I should be able to rebuild a shed or I make something up. I really think I should be able to do something. Maybe, I mean, there's no harm to my neighbors. There's no whatever the example would be. You know, is that...
Well, that's the swimming pool, right?
But yeah, the swimming pool...
It didn't affect anybody. It didn't...
So I think, Rob, I think we need to segregate the two areas we're talking about.
Yeah.
And I think we got to treat them both separately. One is the floodplain variance, and the other is the zoning variance. And I think we just got to look at it separately and decide if we want to have the definition in the floodplain or change the language like you suggested that it isn't because rural rights. It's an exceptional remedy.
So I think what I'm hearing, number one, is that for both types, for any variance of any kind, it should be a rare and exceptional remedy.
I think the zoning's always been that way.
Yeah. So I think
Zoning's
that
always been that.
we need
It's
to
always been
reiterate that in the floodplain.
Right.
And then, so what we're saying is that generally speaking, this should be very hard to get, which is much higher than reasonable, in my opinion. So looking only at the general variances, the BOAA variances. I understand the concept of what we've talked about, but I'm not sure how to capture that in section 1. Are you suggesting that it would read something more like, you know, the applicant has exceptional circumstances that are not generally applicable to other lands or structures in the same zone district because of, and these 4 things, or something of that nature?
I think she was saying something different. I think the concept is, because that's what it says now, it's basically saying limitations. No variance shall be authorized unless the board finds all of the following. The request for variance was as a result of A, the usual configuration of the subject property boundaries, B, unique, C, this, D.
Okay.
Right? Is that?
Yeah, I
So
think
the
so.
request
I mean,
for variance,
but
you strike
I would
that whole
suggest-
first part and replace it with the request for variance is because of.
Paul, if you understand that concept, I mean, I think you guys can reword that and bring it back to us. And
Yeah.
Yeah, just to confirm, we're talking about essentially wordsmithing based on the conversation from the dais, that B1, that introductory paragraph,
Yes.
right?
yeah,
Okay.
and also, I know you put a lot of work into that, shepherding that definition through like most of the year, it seemed like, and I apologize for us now saying, oh yeah, we don't need that, but I think it's gotten us to a good place. So thank you for your work.
That's why it's good to do code amendments in the public and through discussion and not just in a vacuum, because we usually end up in a better place.
Yes, that was not lost on me either, that we're like, okay, we're just saying, no, we don't want you to do what we asked you to do, but that's okay. That's, we'll get there. Okay, so that, and do we think that that then captures the general variance? That already has the exceptional remedy language. Extraordinary remedy. And we take out reference to hardship kind of at all in there. Okay.
Right.
And then over in floodplains, we want to put in, to reiterate that it too is an extraordinary remedy. I think that should convey to people the severity of what we're talking about.
And then on that, Katie, if we do using that definition of exceptional hardship, I think you want to take out the word reasonable, if you go back to that definition.
Well, and in that case, it just is, to me, it sounds like it's saying that exceptional hardship means exceptional hardship. I mean, maybe those words just mean what they mean.
I think it's valuable having the concept of monetary inability to maximize your monetary value of the property is not an exceptional hardship. I think that's an important concept to have in there.
But I don't know that that's been the issue with any of the floodplain variances that have been before me on council.
Definitely more on the zoning side.
Yeah.
I get a sense almost that it is more that economics of solving a problem should not be considered in the calculus of exceptional hardship, i.e., it's going to cost me $1 million to rework the floodplain. And therefore, I shouldn't have to spend $1 million. Therefore, I should get this variance. And I guess I would say that, pure economic considerations are not to be in the calculus of hardship.
That makes sense. I mean, that speaks kind of to the pool scenario. They did end up revising the floodplain, and then they were able to build their pool there, and it was much more expensive, but they were able to do.
But I think the idea is that we can avoid most hardship probably by spending money. I mean, it's a unique situation. I mean, it is truly the ones that qualify for the variance when you can't come up with another solution, frankly, by spending more money. So I think that the fact that you have to spend more money does not equate to a hardship.
But isn't I mean,
I'm losing
I understand. I think that you'd like to take the economics out of the decision process, but at some point, I feel like it ends up being relevant. I mean, if we're talking about a $10,000 problem solution, a $10,000 solution, that's sort of one thing. If we're talking about $1 million solution, different situation. Let me go back to the guy with the 3 foot above the bulk plane, or the maximum height. It wasn't his fault. If we had forced him to tear that down and to replace it, would have been, in that currency, $300,000 or more, and he would have been inconvenienced for like 9 months while they demolished everything that was brand new and then replaced that, for a 3 foot difference. And again, if he'd have been gaming the system, different deal. But we heard from builders, from architects, from him, from a variety of different sources. And I'm not sure you can ever, it's an order of magnitude thing. I'm not sure that you can take economics out of a definition of hardship at some point.
Well, first of all, we're only talking about floodplain right now, right?
Yeah. Okay, I missed that point.
Well, but I guess where I go back, and I don't know that I wasn't around for the specific discussion about the house, but to me the situation was it wasn't the owner's fault. It sounds like a builder just misbuilt a house. I'm guessing.
Pretty much.
My sense is that in that instance, I guess I probably would have come down on the other side and said, your builder did something that was unapproved. And your builder probably has an insurance policy. And, failure to comply with your building permit was not the city's fault. And there is a remedy. And it puts the burden directly on the party that erred, the builder. And the city shouldn't have to take one in the teeth and making an exception when there's another way of solving the problem. And so I guess that's kind of the way I use the word economic, but I guess my point is you get a variance when there's no other means to get a result without obtaining the variance. In that one, I think you could have got, it would have been 9 months. Yeah, it would have been a hassle. All those things, but
had to sue the builder.
But none of that was the Cherry Hills' fault.
No.
So I mean, I guess
I'm losing the P here though a little bit.
Okay,
We've already.
We're digressing.
15.7.520, and for 16.7.530, we've said, hey, we want to add in the extraordinary remedy, and so we're talking about saying, and now the only thing is because extreme remedy is already in there. Extreme hardship's already in there. Is the only thing we're talking about is whether we want to have a definition of extreme hardship.
Exactly, on the floodplain variance.
Right, on the flood.
So we're digressing back to the other, which I think we've already dealt with. So the question is on floodplain variance. I think it's critical to have the word in there, maximize, where you call it profit from or maximize the use. I think it has to be in there because, for example, the pool, where they were going to say there was an alternative. And maximizing it, maybe they had a nicer pool that was in the floodplain. I remember the case. So I think we need this definition in there for the floodplain. I think it's, unless there's some other changes to it, you may have some other changes, but I think that's an important definition for the floodplain.
And those other criteria are not part of the floodplain variance, right?
Not.
No. There are criteria.
There are some.
It doesn't look the same. Because the other one really just sort of took case law and plopped it all, set it forth. But here, it's, the relevant factors have been weighed in favor of the grant. The floodplain, it's the minimum necessary considering the flood hazard, issued only upon showing of a good and sufficient cause, also very subject to interpretation. Determination that failure to grant would result in exceptional hardship to the applicant, and determination that the granting of the variance will not result in increased flood heights, and now my computer won't go below, but et cetera, et cetera, et cetera.
So the question, I think the question we're looking at is, do we want the definition of exceptional hardship?
Right.
Or do we just want the second sentence, or do we want both sentences or no sentences?
Well, let me ask this quick question real quick for City Attorney, please. Are we getting to the point where an extreme hardship is getting to the point where if we don't grant it, we have affected a takings? Or are they still separate concepts?
They are different, but, if you deny someone all reasonable use of their property, then you're in jeopardy of a legal action on the taking. But, so we have to consider that occasionally.
What does that mean if somebody buys a piece of property that is 99% floodplain?
Like, go back to my floodplain then, what does that mean?
Do we have a piece of property that's 99% floodplain?
We have several properties that are 99 or more.
But they're already built on.
Or more.
There are a handful.
My hypothetical situation isn't purely hypothetical. Let's just put it that way.
Right. Okay. Well, I haven't analyzed that one.
Yeah, I mean, I don't know the answer to that.
That's where I'm getting a little tied up with that, is that, if somebody has a lot that's basically undevelopable, and we tell them, well, too bad, it's undevelopable, you bought it anyway. Under this, they can say, well, then you're denying my variance means that I can't do anything with this land and it's worthless.
But that's an issue that we'll approach when it comes, right? I mean, I don't think how we define this. I don't think how we define this is going to put us in a position where we can't consider that.
Right, because it comes back to saying, and again,
Maybe
It's
that's.
good to theoretically, but are there any lots currently in the village that are 95% floodplain?
I'm aware of 2 off the top of my head.
That are currently lots.
Currently, lots that are undeveloped,
They
that don't need to be subdivided are current lots. Someone could submit a floodplain variance and application tomorrow.
And they could do it now.
Yeah, absolutely.
And these rules would apply.
Jay, don't we have some floodplain designation? We're a certified, not floodplain manager, but do we have some?
Yeah, Paul, we are part of the FEMA.
Are you talking about the community rating system,
Yeah.
CRS?
Well, I don't know if that is what I'm talking about, but I guess what I'm asking is, aside from these provisions in here under floodplain variances, do we jeopardize our status with our certification if we were to go out and provide a variance to build in a floodplain?
Our city manager has.
Yeah, I'll jump in on that one. And yes, we do. FEMA will periodically do friendly visits, and they ask for any variances that you've done, and are they in compliance with FEMA codes as well as city codes. And if they're not, they will have a problem with that.
And we had something arise last time. Was that
Fence.
with you or with Chris? Where there were like 2 properties identified that were like they made changes to the floodplain or something, and now there were 2 properties that were in, I don't know, I don't remember, but it came up.
Yeah, and I'll note our criteria is more stringent than FEMA's. So,
What if we were, instead of talking about in the definition the reasonable use of the property, what if we talked about unreasonable impairment of the use of the property? I'm not sure how that's different, but it sounds like a higher standard to me. It says that you're being unreasonable, or it seems to me we want the concept of that the impairment has to be extreme, right? It can't just be a minor impairment.
One of the things, and I was looking at this, and I know sometimes I get focused on words. I actually, now that I've been reading and looking at this, I actually think the word "the" is a problem. The reasonable use, i.e., I want to put this in there, and that is the reasonable use, as opposed to you take it out. You're being impaired from reasonable use of the property. You've already got reasonable use of the property. The, I think, is what's causing an issue for me, now that I think about it.
I don't know.
You're coming here.
Reasonable
It probably doesn't help, but I don't think it's.
But I think it's a question.
Oh, no, it's not but just trying to get to it as opposed to
But
going.
I also think it's a question of how big is the impairment. If it's a minor impairment of the reasonable use of the property, that's not exceptional to me.
Right.
It has to be a significant impairment.
I agree.
So I liked what the track you were on with the unreasonable impairment.
Well, and that's why I went back to my question about takings was, we want to say, I mean, obviously we're not trying to affect the takings here, but we are trying to make this difficult, or not make it difficult, but that it's the exceptional remedy that we talk about. So somewhere less than a takings, but more than
A minor impairment.
minor impairment is the standard that we're looking for here. Because
Yeah, and so maybe it is an unreasonable impairment. And whether it's reasonable, I mean, maybe you just get back to the definition of what's reasonable or not. But if it's in the flood zone to begin with, then whether you're being unreasonable or not, I think is a higher standard.
Well, it almost seems to channel my Google Law degree. It almost seems to reverse the burden of proof, right? Mm-hmm. From us trying to say whether or not what someone wants to do is reasonable or not, versus them having to demonstrate that what we're deciding is unreasonable. And that's...
So what's the wording that we're looking at here then? I mean, that's
exceptional hardship means the unreasonable impairment of the use of the property.
Does that mean, though, that the more impaired the property, the better chances an owner is going to have to get relief from this board?
Well, and so
because that to me is backwards. I mean, it doesn't feel right. Does it mean that if we are the more impaired the property is, the higher likely they are to get relief from the council?
No.
Well, yeah, so if you had one of these 99%.
That's what I think we're saying right now.
I would say just the opposite. That the more impaired the property is, the harder it is for us to be unreasonable. Well, because it's in such a bad situation.
But so let's look at these. Yeah. We have these lots, right, that are 99% in the floodplain. Thinking to ourselves, somebody has this lot, they own it now, they come to us, they want to build a house there. First question, how many people think that they should be allowed to build the house? That's the first question. I think they should.
Well, it depends, in my mind, on whether there is a house there and they bought it with the belief that there was a house and they want
I don't know, let's say they've owned it for 50 years. Since the city of Cherry Hills was incorporated and none of this floodplain stuff existed and whatever.
But it's not a vacant lot.
It's a vacant lot.
Oh, it is a vacant lot.
It's a vacant lot. There's no house on it.
I think what you're going to say is they should be able to build it subject to bringing it up to code and spending the amount of money that it takes to do that, right?
Well, I don't know because it might not be possible to bring it up to.
I mean, you're talking about filling in the floodplain. Right.
Yeah,
that's the way to bring it up to code is to get it out of the floodplain.
But you cannot do anything that increases flood heights and additional threats to public safety. So it might not be possible. Maybe they have to build it on stilts. I don't know, but I think if you own a lot, that it is I think that is an unreasonable impairment for us to say, I'm sorry, that lot is now worthless because you cannot build anything or do anything with it.
But if you bought it with that, if you bought it with the full knowledge.
But let's say you've owned it.
Okay.
But I go back to my question again. I'm sorry to keep doing this, but going back to the idea of takings, where saying that there is no reasonable use of the property as a result of your regulation or no use of the property is different than saying you can't build a house on it. There might still be many uses to a property.
Not a residential lot.
Well, I'm guessing here that city attorney can probably come up with the better takings analysis than I'm about to give. But the idea is we are not allowed through regulation to take away all of their uses of the bundle of sticks so that the property doesn't have any value. Now, is the only ability to gain value from that piece of property by building a house? I don't know.
Yeah, but we didn't take that. We need to be clear here. I don't think we're taking away that opportunity to build.
If there's a lot that is already zoned residential in Cherry Hills Village, that's 99% in the floodplain, and now we say you can't build.
But you're saying, you're saying it wasn't in the floodplain when they first got it. So FEMA came in and redrafted the floodplains.
Or I don't even know what the scenario is, but there are lots out there today.
Ask the guy who would look at
residential zoned, which means use by right. You can build a house on.
Ask the guy over here who's going to look at the application.
Are those
that walks in the door? What do you do with it?
Yeah.
I have these conversations and I say you have to get approved for a floodplain variance first, which requires the city council ultimately will find to approve with conditions or deny the request based on the approval criteria. Some of the approval criteria are subjective, the criteria that we're talking about tonight, the exceptional hardship. Some of those criteria are technical in nature. Can you demonstrate through the model a no rise of 0.00 in the base flood elevation? Most of the time, that's where the conversation stops because folks understand that that is a long process, can be complicated, and can be very expensive just to satisfy the technical side of it, let alone the subjective side of it. And so that's my answer when I get that question is, here's the floodplain variance approval criteria. You're going to have to justify, and council's going to have to agree with you that both subjective and objective criteria have been met.
And is that objective criteria, is that a FEMA requirement or a federal requirement?
It's based in FEMA requirement. Ultimately, it's our code, it's our requirement. To City Manager Thorson's comment, our requirements are above and beyond what FEMA would require, but that's the genesis of the requirement.
Does not reasonable use of property, there's an assumption going on that reasonable use of property means you have to be able to build a structure on it. Does not the state of the property in and of itself determine reasonable use? You got a property 90% in the floodplain, by definition, I'm going, you're not going to build a house on it, but you probably can hunt on it, or you can have ducks on it, or you can do this, or you can do a lot of things with it, but you can't build a house on it. And is that reasonable use? Because there's an assumption that reasonable use means you have to be able to build a house on it. Is that implicit in our rules? Is that's kind of an interesting question now. I hadn't thought about that until just now. Is it?
I said it's an interesting question.
Yeah, that's.
I mean, I'm just going to say this is a really great discussion. It goes way beyond what we were thinking about.
Well, right.
And one that maybe we should keep thinking about, let staff maybe go back and look at. And
that's actually where I was going, Councilor Sheldon, is, I mean, one option tonight is, okay, I think we have a good idea that you're happy with most of the things and what to do with 16,520 on the regular variances. But you could just vote down this ordinance and say, go back to the drawing board and we need some more research and we need to understand, or
approve the minor technical changes without the definition. And direct us to go back to
come back second reading.
Would that be helpful to you if we did make those minor?
It would be helpful, yes.
I think we should do
and I don't think anyone objected to those minor technical. I think you wrote them down. But
well, you're saying they're minor. I mean, I don't think they're minor. I mean,
that's how they've been referred to tonight.
Oh, is it? Okay, good. And by the way, can I ask a question in that regard? When we make changes to our zoning ordinances, are we not required to have a public hearing? I guess we're not.
Not under the code as it was revised in 2019.
Okay, good. Because I'm the.
It's a
sometimes
streamlining.
we make housekeeping, but I'm going. It's pretty significant when you sit back and add in, hey, floodplain zone variance is an extraordinary remedy. That's not insignificant.
Yeah,
that's why that's going in there. That is not an insignificant addition to
the code. I agree with it, and I actually ask myself that question every single time we revise our text, just out of habit, right? That's the way it's written.
And just for my own clarity, right, what we're talking about is some of these removals, i.e. taking out the and unnecessary hardship or hardship and clarifying in the variance to reference the separate section, and then some changing of the phrasing. What would be done, so these would essentially be the three changes. It wouldn't be any additional language.
No, there's more. I mean, we've already agreed.
Yeah.
We've already agreed with regard to, I thought we had.
Well, we haven't voted on anything, so.
Well, okay, yeah.
Yeah, we got to come up with a motion that.
But I mean, we're discussing 16.7520. We were going to do Susan's change, which was limitations.
But he's going to bring that language back to us.
Yes, that's where I'm headed.
Just talking about the small changes like that's on your screen.
Everything before we get to the definition of floodplain development.
So what we.
Well, it's just that one section, right?
Is it just this one?
So as part of the resolution, it would be these three changes, not including the definition. We as staff, myself and the city attorney's office, will circle back based on this conversation and basically bring back revised sections for the variance and floodplain variance based on this conversation.
So I think what we're looking for here is a motion to approve the changes to 16.7520E and 16.7530F1 as presented. And then everything else will come back to.
And then real quick, I just want to put one more example on the table here. We've talked about the 90+% in the floodplain. As many council members know, my family used to own the property at El Camino and Holly. It's 2/3 in the property is in the flood is above the floodplain. The bottom third of it is in the floodplain. When my family bought it in 1964, we obviously didn't have any of these things. When it came time to sell that piece of property, there was a deduct for the lack of development opportunity on 100% of the property. So, saying that somebody is on par just because they bought into a floodplain may not be accurate. As Councilor Sheldon said, you probably didn't do your due diligence when you thought that you would build your dream house in the middle of a floodplain. That's not what you said, but your idea is you buy a property, sometimes you know what your limitations are going to be with that. I think the example that might be what we know, that for those of us who know that piece of property well, is somebody did buy that piece of property and they developed from the floodplain line
That
to the
explains
north.
a lot, Rob.
And that's why the fence
I always
line-
thought that was such a weird.
That's why there was a fence on the south end of the property that goes down well before El Camino.
Yeah.
And, you know, to me, the question comes into play is, would a variance to have allowed them to have a driveway or some other entrance from El Camino instead of the busy street or Holly Street been something that we would not have granted through a floodplain variance? Because to me, that would have been a reasonable accommodation or entrance. I mean, assuming they satisfied the
I think
technical
I can
criteria.
say with some confidence that it probably would not have been granted because there was an alternative to do it from
by doing Holly
yeah.
Street.
So,
Well, and it's interesting because, you know, when you talk about planning, do you want more cars on Holly Street coming in and out of a more busy street than the limitation? Yeah, it's an alternative, but is it a good alternative when you're putting zero speed traffic onto Holly Street? I don't know. I'm just saying that that's another example of a floodplain variance property besides these ones that are way in the floodplain.
well, and I think it's also a good example of how our change in policy over the years represented an economic loss for the owner of the property when you went to sell it.
I'd like to make a
I'm not sure it
motion.
was our change in policy as much as it was the FEMA floodplain map.
No, it's
change.
our change in policy that there are certainly elements of FEMA's floodplain, but, and I'll use the pool as an example, they had all kinds of, they had certificates from people saying it was no rise, saying it was, and we said, no. Our policy is that we don't build in the floodplain if there's any viable alternative. And the same thing with the driveway, you know, they could probably have done it in a way that would have gotten them the no-rise certificate, which is what is required by FEMA. But just given the council discussions that I've participated in, I don't think that would have passed because we would have said, no, our policy is if there's any alternative. So I do think it's our policy and our execution of it that.
And that all fits within that definition, what you just described, so.
Yeah. Okay, so
I'd like to
what
make
we're
a
looking
motion.
for is a motion to approve the changes, as I said, 16.7.520E, 16.7.530 F1.
I move to approve Council Bill 14, Series 2023, amending Articles 7 and 9 of Chapter 16 of the Municipal Code.
Or just 7, actually, sorry.
Okay, you're right. I'm sorry. Article 7?
Yeah, amending Article 7
Chapter 16,
of Chapter 16.
the Municipal Code with respect as insofar as it applies to Section 16-7-520E and 16-7-530 F1. Is that correct?
Second.
That motion has been seconded. And is that a roll call or a?
Yes, roll call.
That's a roll call. Will the clerk please call the roll?
Counselor Eber?
Aye.
Counselor Holen?
Aye.
Counselor Wheel?
Aye.
Counselor Sheldon?
Aye.
Counselor Blum?
Aye.
Counselor McGuire?
Aye.
And that passes unanimously.
And
And
so for clarification, and you're going to go back and bring us new language with regard to the other substantive sections that we've talked about and changes that we've
Agreed, yes.
Right?
That, because those are substantive changes, those we'll bring back to a more formal discussion with council.
Yeah. And I know that was a long discussion, and I appreciate everyone's participation. I think when we don't have these kinds of discussions amongst ourselves, this is when we get, we send people off, they do a lot of work, they come back and we say, well, no, that wasn't what we wanted at all. And so and And that's kind of frustrating for everybody involved. So I appreciate that we are hashing these things out.
Madam Mayor, if I may, I would just say from a staff perspective, it's also extremely helpful for us to hear that discussion, right? Because we're the ones that meet with these owners, and we often get asked, well, what do you think council would do? Or what is council's opinion on this or that? And so hearing this discussion is incredibly helpful for us. So thank you for that. And that is sincere.
Thank you. Okay. Moving on to Resolution 46. And that is that Clerk Gillespie? Yes.
Yep. Good evening, Mayor Brown, members of City Council. Staff is proposing several changes to the fee schedule resolution tonight. 2 are based on ordinances that Council passed on second reading tonight, and that would be the removal of the drone registration fees and of the security alarm permit fees, just to make our fees conforming with the new code as approved by Council. And also we're doing a clarification to show that liquor license fees are the maximum authorized by the state. That isn't any change, it's just a clarification so that there's no question in the fee schedule what that means. And happy to answer any questions.
Yeah, I had one question, just out of curiosity. I mean, we say that for liquor license, the fee is the maximum authorized by the state. Is that right?
Yes.
Doesn't that seem odd to anybody? I mean, what if the state, it just seems so weird to me. No? So if the state said $500,000, we're good with it.
Unless we changed it as a result of that.
Yeah, I think if they did that, we would change our fee
We follow a lot of other
structures.
jurisdictions' benchmarks for fees or other things we set, just like people follow ours.
Well, and fees are technically supposed to offset the cost, right, of providing that service. I think if the state went haywire, we would just change this resolution again.
Well, picking up on what you said, it's supposed to represent basically fees are supposed to represent our cost. The state doesn't know anything about our costs. The state's setting of the fees has nothing to do with our costs. It's got maybe with their costs.
Yeah, and it's so they're pretty nominal. They try to cover staff costs. They never fully cover city attorney costs, as many of our fees kind of don't. We're not able to pass that on completely. But if there were anything that didn't seem to follow our actual costs, then we would come back. This is just a easy, standardized way for us to not have to change those particular fees every time we're able to try to capture all the costs that staff go through for the liquor license application.
How many liquor licenses do we have? Like 4, 5, 6? No, we probably the clubs and the restaurants.
Right, we have I think 6.
Okay,
It's not a lot. And just
But I presume that when someone comes to us and says, hey, well, like I said, we don't have anybody get new ones, but if they did, we wouldn't sit there and go, hey, go check it out with the state and find out and come back to us. We'd tell them what that is.
Oh yeah, it's an easily downloadable form.
Because that's the whole point of this schedule, is to advise applicants as to what the fees are in terms of what they're applying for, right? I mean, that's...
I wouldn't usually, if an applicant came in for a liquor license, the package I would give them would include the state fee schedule, not our resolution, since our resolution doesn't itemize out all the different types of liquor licenses and their associated fees, and the state does.
And just for context, Councilor Holen, I mean, previously column 2 here said NA, and I thought that was less clear. Yeah. So this was just a tweak to be sure that there's really no substantive change, and the practice is going to be there, and the fees are going to track, if not under track, costs incurred in the program.
And I saw the NA, and at that point I'm like, well, what's that? But then I went to this, and I said, okay, what's that? So.
All right, so are there any other questions about the fees? No? Motion?
I move to approve Resolution 46, Series 2023, amending the fee schedule.
Second.
Moved and seconded. All in favor?
Aye.
Any opposed? That passes unanimously. The contract for services with Rogue Architecture. Director Goldie.
Good evening, Mayor and members of City Council. This evening, staff is requesting approval of professional services agreement with Rogue Architecture for the production of construction documents for the modification and reuse of the big barn at Quincy Farm. Earlier in 2023, the Cherry Hills Land Preserve issued an RFP for a feasibility study to be performed on the big barn at Quincy Farm, which Rogue Architecture was awarded. The feasibility study looked at the existing structure and the adaptive uses of the barn for a wide variety of programming while retaining the historical exterior of the barn and as much of the historical interior as we thought was feasible. So staff participated with the Land Preserve in this process and were pleased with how Rogue Architecture completed the scope of work. They went above and beyond their original scope without upping the prices for the Land Preserve on that. They're very vested in this barn, and staff feels that because of the work Rogue Architecture has performed on the feasibility study, that their knowledge of the structure is in the best interest of the city to utilize their services. The code allows for an exemption from competitive bidding, stating that contracts related to public works for services of individuals or entities possessing a high degree of professional skill, included but not limited to architects, engineers, attorneys, so on and so forth. Staff is confident that the cost provided by Rogue is within the industry standard, which is between 10 and 20% for renovation of an existing building, according to AIA. Staff can answer any questions at this time.
I had a couple of questions. In looking at what they're doing and what they're not doing in the exhibit to the contract, I think that's what this is, table of contents, the feasibility study, I guess. But I think it also ties into the contract. Under structural engineering, there were a couple of things I didn't understand why they weren't being done, which makes me think they're being done somewhere, but just not here, perhaps. Determination and basis of structural loads, structural analysis and calculations. So I'm sorry, I'm looking at page 246 of the package. Are those not things that we're having done?
I'm sorry, you're looking at the feasibility study.
Okay.
So that wasn't part of the feasibility study that's already been completed. That will be part of the construction documents that we're contracting for now.
So we just included the feasibility study as one of the attachments under the contract.
Okay, so that's not an exhibit to the, I guess I thought.
Correct, that's not an exhibit. That's just a
couple of pages before that is Exhibit A.
I see, okay.
Which is the scope of
yes,
service.
and all structural is included.
Okay, good. Then I misunderstood. Thank you. Why did is this what the increase in $11,000 in the budget relates to for the big barn? Or was
yes. When we did the original budget, we had not negotiated with Rogue yet. That was just a guess of our fees.
Okay.
And so the $11,000 brings it up to the $72,000 total.
Okay.
Is the total cost that we came up with.
Randy? I was trying to reconcile in Exhibit B, it talks about lump sum of $30,000 not later than January 31, 2024. And I think we're asking for that $30,000 in 2023. Am I missing?
No, we have $30,000 budgeted this year, and then the additional $42,000 next year.
Okay.
So we are going to pay $30,000 of this contract this year and $41,000 next year, or $42,000.
Okay, so right, it seems like we're paying the $30,000 a little in advance. Am I misunderstanding?
Yes, some of that will be a little in advance, just so we can keep our budget straight, and audit-wise, we are not changing that.
Okay, thanks.
Yep.
I had two questions. That was exactly one of them, so thanks for picking that up. And then the attic is still not part of this scope, correct? They're not going to go up into that attic and try to structurally get it to the point where it's usable?
Not the attic itself. We'll be up in there to structurally fix the roof, but not the floor of the attic.
Right. We're not going to make it a usable space at the
Correct.
time.
Correct.
Okay. All right.
I
Thank you.
think that also dealt with ADA.
Accessibility, yes.
Yeah.
I get it. It's a neat space up there. If you can
I
figure
know.
out a way to get there, and I suggested to the land preserve maybe access stairs outside on that south side of the building. There's that double, I think it's a set of double doors that goes out to.
But I don't even know if stairs are sufficient. Because ADA.
Anyway.
Yeah.
Thanks.
Any other questions?
Give me
If
just
not,
a second.
oh, yeah.
I'm sorry, just give me. I had one more. I'm just trying to find it. Okay, that's still okay. I'm good, thank you.
Okay. Then I would entertain a motion.
I move to
go ahead. Oh, please.
I move to approve the professional services agreement with Rogue Architecture in the amount of $71,250 for production of construction documents for the renovation of the Big Barn on Quincy Farm as outlined in the scope of work included in the professional services agreement as Exhibit A. I further move to authorize the city attorney to make such changes as may be needed to correct any non-material errors or language or to negotiate such changes to the agreement as may be appropriate and do not substantially increase the obligations of the city, and to authorize the mayor to sign such agreement when in final form.
Second.
It's been moved and seconded. All in favor?
Aye.
Any opposed? Well, we are just all on lockstep tonight. That passes unanimously. I will now recess the council meeting at 8:30 p.m. and convene the meeting of the Cherry Hills Village Charlou Park Third Filing General Improvement District Board. Will the clerk please call the roll?
Board Member Eber?
Here.
Board Member Holen?
Here.
Board Member Wheel?
Happy to be here.
Chair Brown?
Here.
Board Member Sheldon?
Here.
Board Member Blum?
Here.
Board Member McGuire?
Here.
The first item is the consent agenda.
Move to approve the consent agenda.
It's been moved and seconded. All in favor?
Aye.
Any opposed? That passes. Unfinished business, Resolution 4, Series 2023, adopting a budget for 2024. Director Farman.
Good evening, Board Chair Brown and board members. We do have a resolution for consideration tonight that would adopt the 2024 budget and also establish a mill levy for 2024. The estimated mill levy would be 7.00 mills, and that is down from a 10.75 last year, and that's due to the anticipated increase in assessed values. Earlier tonight we did discuss the Senate Bill 23B 001, and this resolution includes some language authorizing the city manager and finance director to certify the final mill levy to the county due to the new filing deadlines. So the county does have until January 3rd to finalize the assessed value, and the city has until January 10th to certify the 2023 mill levy for 24 collection. The preliminary assessed value results would be $24,944 in property taxes, but the minimum amount of property taxes needed to fund debt service is $24,500. So depending on what the county comes in with assessed values, the finance director and city manager will determine the exact mill levy in order to meet debt service requirements. So that's the twist this year in the resolution. The 2024 proposed budget is $26,110 for debt service and administrative expenses, and the projected ending fund balance for next year is $34,629 to meet required debt service and TABOR requirements. I can take any questions about this resolution. Otherwise, we have a recommended motion.
Thank you for that. Any questions? Otherwise,
I just have one,
yeah?
and it's not necessarily about the budget itself. It's about the procedure in which we got here. And I don't know that it's a critical piece, but I do recall at one point, maybe a year ago, when we were approving the budget for the 2 GIDs last year, that I requested that we make sure to notify the owners within that GID, those 2 GIDs that we were doing these budget hearings. They're such small groups of owners that went to the effort of voting on including themselves in these taxing districts, that I thought it would be a good idea to make sure that we included them in a notice that we were hearing them tonight. Maybe somebody's watching, but can staff confirm that we've done that?
Yes, ever since that direction, we've been sending letters that go out to all the GID member resident properties, and I try to send them out the day after the previous meeting. So the ones for this meeting went out after the November 21st meeting.
Great, thank you.
Thank you very much.
No further questions.
Hopefully some of you are watching tonight. If there are no other questions, I'd entertain a motion.
I move to approve Resolution 4, Series 2023, a resolution of the Cherry Hills Village, Charlou District. All right. Charlou Park, third filing GID, Board of Directors summarizing expenditures and revenues, adopting a budget, setting the mill levy, and appropriating funds for the GID for the calendar year beginning the first day of January 2024 and ending on the last day of December 2024.
Second.
It's been moved and seconded. All in favor?
Aye.
Aye.
Any opposed? That passes unanimously. Thank you very much. I will now at 8:35 adjourn the meeting of the Charlou Park Third Filing General Improvement District Board and call to order the meeting of the Cherry Hills Village Southmoor Circle and Hudson Parkway General Improvement District Board. Will the clerk please call the roll?
Board Member Eber?
Here.
Board Member Holland?
Here.
Board Member Wheel?
Happy to be here.
Chair Brown?
Here.
Board Member Sheldon?
Here.
Board Member Blum?
Here.
Board Member McGuire?
Here.
Randy's happy to be here. They're getting a little less happy with every time. All right. The item is the consent agenda.
Move to approve consent agenda.
Second.
Moved and seconded. All in favor?
Aye.
Anyone opposed? That passes unanimously. Resolution 4, Series 2023, adopting a budget for 2024. Director Farman.
Good evening again, Board Chair Brown and board members. This is a resolution for consideration tonight which adopts the budget and establishes a mill levy for the General Improvement District for 2024. This mill levy is estimated at this point in time at 12.80 mills, and that's down from 18.1 this last year. And due to the state Senate bill, the resolution does include language authorizing the city manager and finance director to certify the final mill levy to the county due to the new filing deadlines. The preliminary assessed value results in 19,212 property taxes, and the minimum property taxes needed to fund the debt service is $18,000. The proposed budget is $19,070 for debt service and administrative expenses. The 2024 projected ending fund balance is $11,857, and that is required to meet the $10,000 debt service reserve and Tabor restricted reserve requirements. Are there any questions about the budget for next year?
Got one quick one, Director Farman. The 30% decrease in the mills is a direct result of the AV going up. Is that how we balance that?
That's exactly right. Yes.
Okay. I just want to make sure. I mean, these lowerings of those mills is pretty incredible. After 1 year of issuing those bonds, or maybe two now, to see them go down by that much says a lot about the AV going up by that much.
Yeah, it does.
No further comments.
If we reduce those mill levies, are we subject to Tabor at all with this if we want to go back up?
GID, the way it was approved. Yeah.
Okay.
Allowed for the float.
Okay.
It has to cover debt service, basically.
Good question.
Okay.
Okay. If there are no other questions,
I move to approve Resolution 4, Series 2023, a resolution of the Cherry Hills Village Southmoor Circle and Hudson Parkway General Improvement District Board of Directors summarizing expenditures and reserves, adopting a budget, setting the mill levy, and appropriating funds for the GID for the calendar year beginning on the first day of January 2024 and ending on the last day of December 2024.
Second.
that has been moved and seconded. All in favor?
Aye.
Any opposed? Hearing none, that passes unanimously. I will now adjourn the meeting at 8:39 p.m. and reconvene our city council meeting. Moving on to reports. I have been participating in calls, Zoom calls regarding potential legislation affecting accessory dwelling units and transportation-oriented development. There are still a lot of unknowns. Draft bills are, if even existent, are only skeletons due to the special session. All of the bill drafting has been pushed back. The conversations sound scarily the same as they did this past year. So there's still a lot of unknowns, and we're monitoring it very carefully, but working on that. And then I also wanted to just take a moment to address, there have been, within the last month or so, last 3 weeks, there have been two kind of scary issues involving burglaries in the village, and I know a lot of our citizens are frightened about that, and I'm sure our commander will address it as well. But I wanted to make sure and be clear that there have been no cuts to funding to the police department. Our police department has never been denied a request by the city council. They are fully funded, fully staffed. The drone is still being used. And I just want to make that very, very clear. These situations are traumatizing. I feel for the victims. I'm so sorry that anyone ever has to go through this. But I would like to commend our police department in the rare cases where we're not able to prevent these crimes. Our police department has been incredibly responsive, and I think that's well beyond what residents of our neighboring communities could ever hope to expect. And as a result of their fast response, suspects have been apprehended and progress has been made. And so while I know it doesn't undo the fact and the trauma that people have already had to endure, I hope that, the next best thing is to get the bad guys. And I think our police department is doing a great job at that. So that is my report, and I'll start at this end with Councilor Ebert.
Thank you, Mayor. Just a couple of things that are pretty small. First, we previously have had discussions about we previously have had discussions about access to our public trail system, and I've had a couple of phone calls recently about an issue in Councilor Holan's district regarding Buell and the eastern entrance to the Cherry Hills Village Trail that's on the south side of Buell. Specifically, I've been approached about whether or not that is blocking a public access to our trail system. So it brings up some ideas and discussion items that we might want to have. I don't think I've got it fully formulated yet, but the idea here is that a neighborhood has been in the idea of either safety. There's a dog park now, apparently, that has been installed in the area immediately to the south of the clubhouse, just to the east of the tennis court. There's a little sliver of green grass in there that came right out onto the trail. It involves a fence and a lot of uproar by a lot of residents, apparently, that they no longer have what they thought was access onto the trail at that point. It appears largely to be an issue with the HOA. Apparently there is a great deal of turmoil within that HOA. But I do think the issue goes to the idea that we may want to have some discussion about making sure that we have the means to protect access onto our public trail system. Roads can be vacated that we currently use for access to our trail system. And I think that we need to at least have discussions about how we make sure that we always have access to our vaunted and highly preferred trail system that is in our village. Secondly, Again, I've talked in the past about my experiences with numerous instances where numerous residents have failed to obtain building and or fence permits. I think it's gotten to the point where it seems to be an issue that I know we're going to talk about going forward about, are we reactive or proactive in the city's approach to enforcement matters, largely involving permits and the enforcement of them. But I guess the second part that came up to me was a discussion I had a little bit with city manager, and that apparently we have the authority to double our permit fee requirements if we catch somebody not having gotten a permit, and then they have to come back in and get a permit. And I guess there's some discussion about whether or not we have been enforcing that provision. And so I don't have an answer yet, but I thought that that was a pretty reasonable means to address and prod people towards the idea that it's easier to ask for permission in advance and get the permit rather than having to come between your tail between your legs in reverse and ask for and be assessed. What I hope we are assessing is a penalty for the negligence and failure to get that. And specifically where it comes into play is a lot of people hire building fence contractors. And the fence contractor gives you the, I'll take care of all the permits. And then they don't. Or they don't do it up front. And it's put Paul, and I know it's put Jan in some difficult situations where they're playing catch up, unfortunately. And it just seems, in my neighborhood alone, I've probably had 6 or 7 instances in the last 4 or 5 months, which if you multiply that by the citywide, it seems to be an unacceptable number. It goes a little bit to what I'm going to write about for my crier article and trying to be respectful of the community and the rules and regulations that we all are playing by. But I do think that that's something that's out there. And, city manager, if there's anything that you have on that idea, or Paul, if you have anything in terms of the ability for us to seek the fees, and are we doing that, I'd be curious to know what our status is on that.
Offhand, I don't know, but I can check the code and let you know if we have that authority.
Other than that, I did attend, Mayor, I came right after you lit the tree the other night. Very enjoyable winter festival last Friday night to those who were able to come and attend. I thought everybody had a great time. I will tell you, it started at 6 o'clock, and I got here at like 6:15 and couldn't find a place to park. To those people who came and enjoyed themselves, it was awesome. There was not a place to park in the elementary school. Everybody came right at the beginning. It was a great evening, great warmth. Many thanks to all of the city employees that took a lot of time to put this thing together. It looked great. People had a really fun time, I think. And it was quick in, and by about 7:30, even though the event went till 8 o'clock, by about 7:30 it was pretty quiet and gave everybody a chance to breathe. But it was really a nice city event, and the number of young people and young families that are in the village gives me great hope that there's a lot of enthusiasm, a lot of interesting and fun people that are in the village. So I'll close by saying happy holidays to everybody. To those celebrating Hanukkah, tomorrow night is the first night of Hanukkah. I wish you a very wonderful and wonderful Hanukkah, and followed immediately behind us Christmas. Merry Christmas to all. Celebrating Kwanzaa to those who celebrate Kwanzaa. And if you don't fall into any of those categories, I wish you good health and happiness to finish calendar year 2023 in any way that you do so. Thank you.
The only thing I've got to add, this is something I passed on to the city manager and to the mayor. You're all aware, Governor Polis, wrote a letter and then had an editorial saying that residents should be talking to their municipalities to try to get their real estate taxes lowered. And in an interview with Axios, he said, quote, "We at the state level can't really microengineer a statewide solution for everyone. That's why it's in the hands of local elected officials," Governor Jared Polis told Axios Denver in an interview yesterday. Governor, I agree with you. That applies across the board. It applies with regard to affordable housing issues that you're putting into place. Other than that, I also wish a happy holidays to everyone.
Thanks, Councilor Holland. Mayor Pro Tem Wheel.
Thank you. Thank you, Mayor. Well, I'd be remiss if I didn't thank everybody for all the support on the Bellevue median. It is under construction as we speak. They've torn out the median and they're busy rebuilding. Jay and Ryan and the crew have done a terrific job as well on staff. So neighborhood's very appreciative. And I'd echo Katie's comments about some terrific police work that's been happening recently. You know, I know that some of it's not public, but it's great stuff, and you guys ought to be very proud of that. And some of the information that's been circulating, you know, contact myself, my colleagues, my peers. You know, some of the information is not accurate, and we'd be happy, I think, to provide accurate information. No news from Dr. Cog. We had the work session was canceled. I do think that in January we're going to start to get a whiff of some of the work that's been done on broader economic planning, land use planning, rather than, you know, transportation only. So I look forward to sharing that with you as it becomes available. And let me add my wishes. Happy holidays to everybody. I'm looking forward to it. And I hope you have great holidays as well. Thanks.
Awesome. Thank you. Okay, and happy holidays there. Okay. Let's go down to the end. Susan.
Sorry, I was expecting to go last.
Sorry.
I don't have a lot to say. You know, as I'm wrapping up my first year on City Council, I have to say I get a lot of questions from people about, oh my gosh, how much work is it? You must have to spend a lot of time doing it. And you know, my uniform answer is, it's not nearly as much work as I thought because the city has an incredible staff. I said, these people are always prepared. They always seem to know the answer to the question, except Paul didn't know an answer just then. So
except for Paul.
But I routinely sing the praises.
Sorry to ruin it for the rest of you.
To people, and I said, you know, it really makes a difference, I think, in how the city runs and how well things go here. So I then thought, well, I probably ought to tell the people here that also, because I don't know that we give you guys enough credit for what you do. So I do want to say thank you. It's been a big year. A lot's gotten accomplished. And we do appreciate all the hard work. And I am out there singing your praises. And when I get questions about what's going on with crime, again, my response is we have an incredible police staff. They're using they've requested resources. We give them the resources. They're using them. And I encourage people to get to know the people in the police department. So thank you. Yeah. And happy holidays.
I have no report, but I do want to say that I did attend the Winter Carnival. I thought that was wonderful, and what a great turnout. And the other thing is kudos to the police department, because I've been staying in touch with the chief, and everything they've been able to do, we really appreciate on behalf of the City Council. And happy holidays to everybody.
Thanks, Al. A couple things. The agenda for January 16th has potentially the second reading of the variance and floodplain variance discussion that we just talked about, spent a lot of time on tonight. If that does, in fact, stay on the agenda for that January meeting, which Jim's shaking his head, probably not.
Not in that format. We may have a study session that night.
That's what I was going to suggest, is that if we're really going to stay on agenda for this night, that you get us some stuff in advance of the meeting so that we can start digesting it and try to have a little bit more productive meeting. I'm not saying what we did tonight wasn't productive, but we're all trying to do it right here for the first time, reading a lot of this stuff and thinking it through together. And I think if we were to have some kind of collaboration, either offline where we can all be thinking about this stuff, if you have questions to ask of council, if that's appropriate, or in a study session sometime in the early new year, that would be nice as well. Canal Collaborative, Highland Canal Collaborative Leadership meeting is tomorrow. I'll be attending that, probably with some other folks from staff, I would think, maybe? Jay? Okay. Great. And then I'll report back to council in January with what I find out, what's happening with the canal. I know I asked the question of our staff at our last meeting, what's happening recently with the canal, because I didn't know. But now I'll get an update and be able to report back as well. And then I'm just going to maybe touch on this and hopefully open the door. Maybe Jim's going to give an update as to our cell phone RFEI request for expressions of interest. We did get 4 responses to that, and we've started vetting those out. And so I think maybe we'll let staff possibly touch on that a little bit more. But otherwise, happy holidays to all. Thanks.
Thank you.
Thank you, and good evening, Mayor and Mayor.
Be sure to wish everyone
council
happy
members.
holidays.
It's always a good night when you don't have to hear from me, so I think that's a positive. I've got a few things. One is kind of touched on. Our next meeting will be January 16th, so we've got a few weeks in between. Tonight's agenda was pretty packed, and I'm sure the 16th will be pretty packed, and I appreciate council getting through everything that they did. I will say, again, it was mentioned that the budget, was approved with very little fanfare tonight, but, that's a 6-month project for us. I mean, it takes a lot of time, and I want to thank Doug and all the department heads and staff that worked on it. It does really take a whole village to get that done. And I'll thank the council liaisons for all their efforts during that process. So, next week, we'll probably start working on the 2025 budget. So, also, I'll say this, the packets were modified a little bit, and I don't know if the council noticed it, but we added a section called updates in your packet. And that was just so that half of it was for me, because I don't like searching through the entire staff report trying to find things. And so if I can get the update first, then I can find out what else I'm looking for quite quickly. So anyway, hopefully you find that helpful as well. But one little change that happened. As Councilmember Ebert talked about, we're looking at doing a March retreat for council. And so what I'll do is I'll put out an agenda, a really preliminary agenda, and ask the mayor and all the council members to provide input on what they would like to see on that agenda, gather it all up. We'll put together staff reports and all the packet together, and then get that scheduled and make sure we touch on the items that are important to you. And let's see, as Councilmember Sheldon mentioned, we have received 4 RFEI responses for our cell study. The responses are kind of all over the board, and it was interesting. Our consultant had a lot different viewpoint than the staff, and so we're going to work that out. We'll probably conduct some interviews with the companies that did submit and try to get that done fairly quickly so that we can start to identify where we may want to go with the whole cell study. So it's kind of an interesting process, and the responses are all over the board. So we'll continue to vet that down and try to get somewhere where at least we'll be bringing it before the council so we can have some discussion. And with that, I know the holiday tree lighting ceremony was great. I'll let Emily speak to that, but Jay's staff and the whole team really worked hard to put all that together. There's always new things that they build that are always interesting, and I just want to thank that staff for all the hard work they did. And I know it was a fairly chilly night, but not as chilly as some of the other ones we've had. So, and the crowd was fantastic. So with that, that's all I have.
So do you want to do different departments or who?
Sure, we can start with Commander.
We'll start here, Commander.
First of all, thank you, Mayor Brown and council members, for your comments and recognition of the hard work being done across the street by our officers. I'd like to just take a moment and address some of the communications that have been kind of circulating around the city. regarding staffing levels at the department and also a perceived lack of funding of our officers and the drone program. I'll start by saying, I'm confident that the intent of the message that was originally sent out was not so much to bring a negative light to the police department, but probably more so to gain support for the police department. However, I believe that the information disseminated was a result, unfortunately, of a misunderstanding of maybe some things that were overheard or some comments that were made to this person. Regardless, I want to echo that the council and mayor, you guys are wholeheartedly support the police department, and we appreciate that. And like you said, when we've come to you with requests, you guys have always been supportive of what we need to do our job, and we appreciate that. And with that, I'm proud to say that, earlier this year, we purchased a drone program, or we started a drone program. We purchased our first drone. We've been flying that just about every night throughout the second half of the year, and we've had some great successes with that so far. And we've also added it into our budget, which was finalized tonight, to purchase a second drone for next year, which will further help us in providing a safe community. As has been mentioned repeatedly by the chief, he and I are continually monitoring and evaluating our staffing needs, and we know that if need be, we will bring it to the attention of council if we need to increase those staffing needs. As of right now, in the 2024 budget, we are confident that we are where we are to provide the adequate services to this community. Lastly, since you brought up the recent events that have occurred over the last few weeks, these are definitely scary events that have occurred. I can say that the police department has had some incredible working relationships with our residents, either those that may have information related to the crimes or those that have unfortunately been victims of these crimes. And because of some incredible investigative work that's been done by our officers, an arrest has been made, and hopefully soon, based on some investigations stuff that we're waiting to return back, hopefully we'll have some more arrests here coming in the near future. And that's all that I have.
Thank you. Director Workman.
Good evening, Mr. Mayor, members of council. Before I forget, I want to wish you all a happy holiday season as well. Otherwise, I will. Just two quick things. One, I was able to attend the Kent-Denver meeting last night. I'm also planning to attend next Tuesdays. I won't share any details, but I was able to share that both Planning and Zoning Commission and City Council is aware that Kent-Denver has initiated these conversations. For legal reasons, you all won't be able to attend, but that does not reflect a disinterest or anything of that nature related to it. It's just for legal reasons you can't attend that.
Can you speak to, was it well attended? Can you speak to how many people?
Based on the number of invitations, I would say yes, but they expect to have about the same number they had last night at next week's meeting. And they are direct neighbors of Kent, so. Last, I'm very pleased to announce that we are going to be going live with our new online permit system. So look forward to seeing some information related to that here in the near future. While he's not here, I would like to just state in public that Jan has really done yeoman's work on that. He's been kind of a day-to-day contact getting that set up and implemented and put on its feet. And so I think he deserves some recognition for that. If you do happen to get questions or things of that nature related to that system, please feel free to have them reach out to either Jan or myself. Anytime you roll out something new like this, there's a breaking in period. We certainly expect that, but we want to try and make that as smooth as possible. So don't hesitate to give out our contact information if folks reach out to you. That's it.
Thank you. Director Goldie.
Good evening, Mayor, members of council. As Councilor Wheel pointed out, we have 3 years of planning and 3 days of construction to remove the Bellevue Island. That should be wrapped up tomorrow. The rest of the paving will happen during the day, and then the striping should happen at night. If not, the striping will happen after the storm that we are expecting this weekend. I won't take any credit for the winter event. Emily and my parks crew did all of the work on that. I just let them use their creativity to design and do as they would like. There is a Arapahoe County Transportation Forum tomorrow. Are you going to be? Yes, I'll be on that too. Just wanted to make sure because there's a vote and they need a super majority to change some of the grant numbers within the process. So, and I don't think anyone has wished happy Festivus yet.
Yeah, I think it's the way that event has really grown over, since the first time that we ever did that years ago, and all the set pieces that our staff have built. It's really great. So I was just going to ask if Emily was sitting over there because I can't see you, but yeah, she is.
Yes, hello.
Next time she'll be over farther.
Yes.
Is that happening over the holidays? Or when?
Yeah, because we have the 6 week.
It's happening tonight. They're outside right now.
Yes, thank you to the mayor and council members who were able to attend on Friday night. It was a very successful event. We typically base our attendance estimates off of the number of kids that see Santa, since that's the easiest to count. This year we had 150 kids see Santa. So then if you extrapolate to their families with them, and some families that don't go see Santa, we had a ton of people at this event. So we're really pleased with it. It went really smoothly. Folks came up and thanked us. So thank you all for helping us make that happen. And just a shout out to our park staff because they really are super creative, get really into what would be fun for kids this year, custom build things, and then have like a 6:30 a.m. to 10 p.m. day that day. So we just really appreciate them. That's all I have. Thanks.
Thank you. And Clerk Gillespie, I know you're over there.
Just a quick report as we're winding down 2023. I mentioned it to Mr. Holland earlier, but we will be going out for an audit RFP next year because 2023 is the last fiscal year for this contract period for the current auditor. So hopefully we'll have a contract for council to consider in the first quarter of next year. And happy holidays to everybody.
And after Doug gave comments, and again, staff is terrific. We always say that, but with regard to the budget, you did a great job. Everybody did a great job on that. And kudos to Doug because he has to put up with listening and interacting with me probably more than anybody else. So,
extra applause for that. City Attorney.
Just happy, safe holidays to everybody. Thank you.
Thank you very much for the tote bags. All right, well.
Motion to adjourn.
Hearing no objections, we will stand adjourned at 9:07 p.m. Thank you very much. See you next year.
Next year is.
Time marches on, or races on.